even get a proper mail. When I go to participate, they say that you cannot participate because you've been found to be not eligible.
That is over. Yesterday it is over.
Yeah, that's what I'm saying. So now my situation is even worse.
So
now,
what you will require now?
no matter, kindly give me leave, not today, kindly place it tomorrow.
But the tender, it is up to tomorrow. Yesterday.
No, yesterday your lordship was pleased to stay. Now, my lord, whether they have stayed, whether they have proceeded, I don't know. So I fall into the same category, not eligible.
List on Monday.
My lord, may I?
Monday, my
lord, urgent.
Monday.
Very well. So I'll take
That's
your
urgent motion.
ready করে দিচ্ছি দিয়ে দেবো।
My lord,
On 29th of January, without even a show, but I'm not been able to participate.
When you have been blacklisted?
On 29th of January, I have approached this court on 9th of February. Kindly, my lord, I've mentioned the matter, I've given to understand.
Give all the mentioning give to my
My
court
lord,
officer with the reason. I will see to that. If it is urgency, it will
my
give
lord,
a short date.
my
If it is
situation,
not
my lord, my situation is that, my lord, tomorrow is the last day.
court officer.
My lord, in my situation, my lord, it's tomorrow the last day. My lord,
My
my lord,
Give whatever the
my lord, only one, my lord, one.
Give
my lord,
the reason.
Tomorrow, my lord,
You mention the reason. I will consider it and I automatically. It
my
will
lord,
be
the-
fixed.
my lord, my difficulty is that, my lord, may I?
My lord, I am. আমি সেদিনও বলছিলাম যে পরে তো ওই জন্য আর কি বলে যান আমার খুবই আর্জেন্সি
Because notice blacklisting. My lord, if tomorrow your lordship kindly give some precedence, my lord, I have mentioned it on earlier occasions.
It is in the list.
Yeah, my lord, it is not appeared in the list till date, my lord. Now,
When
my
you
lord,
when
I
you
have
file the
mentioned
writ petition.
on the 2nd of February, I have filed it. Third, it was numbered. Fifth, I have mentioned. 9th of February also I have mentioned. My lord, now tomorrow is the last day.
Tomorrow is last date of
My lord, the show cause notice. Now, my lord, after
so cause
tomorrow,
notice of.
my lord, this was issued on 14th of January for blacklisting.
Now,
my lord, after tomorrow they will blacklist me.
Okay, blacklisting notice has been issued. You file the reply. Or the so cause notice can be entertained in the writ application unless you will not give the reply.
The Supreme Court has held that even the show cause notice can be interfered with by the courts. My lord, if the grounds are not
If
mentioned.
your so cause notice is given, you go to the give the reply. Then if you final order, then you come.
We have responded to the show cause also. We have responded.
My lord,
If you challenge the so cause notice, there is no urgency. So cause notice, you have an opportunity. You go and file a reply.
my lord,
Number 162, 3 and 4. Because this matter was mentioned before lordship on 13th of January. The lordship was pleased to fix this matter on 11th of February. But unfortunately, for some reason or the other, matter did not appear. But I'm mentioning it again upon notice. Lord, again, I put them on notice. Lord, the issue is with respect to Lord, assailing the illegality perpetrated by Lord the successful candidates in holding the medical council election. Now, Lord, next year is the next election fixed. Lord, already prima facie case has been established. Being satisfied, Justice Bhattacharya had directed all the postal ballots to be brought before this honorable court and kept under the supervision of a receiver. Lord, that is there. Now, Lord, a forensic Lord, report has also been taken out indicating what were the problems with tampering of the ballots. Now, Lord, thereafter, Lord, the matter is not being heard. Lord, if some precedence can be given, Lord, any day subject to lordship convenience. Next year, Lord, is the day.
Next year.
Lord, matter will Lord proceed any day. Lord,
This is a valid opposed by learned friends.
Fixed it, Lord, on
This is a hearing matter. When it's subject to correction, there is no forensic report. As what I oppose my learned friend. It's a hearing matter. I don't object to the mentioning a lordship, but on the last occasion when the matter was mentioned and it was fixed, as we have been informed, it was not to notice upon us. We were not
notice is there.
Notice your lordship, it was not mentioned in our presence, but if it is taken up, your lordship, we don't object.
Let us not
No,
get
we
into
were there.
that.
We were there.
noticed- We have noticed that we have served.
The affidavits completed.
Hearing it's ready for hearing.
Let it in the month of April for hearing.
Lord, kindly fixes a date. Lord, kindly fixes a date. Lord.
Okay, come karo. It is in the list.
Yes, 162, 3 and 4.
It is appearing as under the new motion.
2, 3 and 4.
But if your lordship is
Subject-
Just
fixing
a
time,
minute.
only indicate fixed my matter on 18th of February at 2 p.m. I was mentioning because I'm in some personal difficulty.
You are also
on that
there.
day.
You are also there.
But my matter, because my lord, I'll be praying for 18th February. It is fixed by your lordship at 2 p.m. I'm
Different
praying
matter,
for
Lordship.
some personal difficulty. I'll not be in Calcutta, my lord.
Thank you.
This be, my lord, adjourned for that day. Any other day may be fixed. This time can be allotted to my learned friend.
That's a different matter, Lordship. Different matter.
He is telling that instead of his matter, your matter can be
I'm trying to
replied.
help out. That's it.
He is accommodating you.
Thankful to him. My lord. Because I was mentioning only for that reason. my
On
lord.
18th
Some
February,
difficulty.
18th February, you will be ready.
18th
My
February.
lord, I'm led by Mr. Shakhushin. My lord,
Ah. You will be ready, then I will
my lord,
fix.
kindly fix it after, because it's just a week, my lord. It's a hearing matter.
Fix it
Will
on
require some
18th
time. Will require some time.
18th February.
162, 163, 164.
My lord.
Record an order. The learned counsel for the petitioner mentioned the matter and submitted. Earlier, the matter was also mentioned, and this court has directed to release the matter in the 11th of February, but it is not listed. He submitted there is an urgency and affidavit is completed. The matter can be fixed up for a specific date and time for hearing. Learned counsel for the respondent submits that on the earlier occasion there is no notice has been served upon the respondent at the time of mentioning of the matter. Had the learned counsel for the parties let the matter, it is as per the submission made by the parties, it is found that affidavits have been completed, the matter is ready for hearing. Let the matter appear on, give the date. अप्रैल में देखो कौन सा डेट है?
So this matter was 18th February, 2 p.m.
But I think 3 matters. One day it will not serve.
Lord, Lord, subject to what falls from your lordship, Lord, let us, Lord, if your lordship feels, Lord, let's start on 18th
Okay,
of
let the
February.
matter appear on 18th
But the
February.
hearing matter
at
will
2
require
p.m.
some. Lordship will
Aरे
require.
ठीक আছে, start
Come,
करें
come,
ना,
let
तो
me start. I will accommodate you. It
Yes,
is not
let us start.
18th February
Like
2026
that,
at 2
grateful.
p.m.
2 p.m.
2 p.m.
2
At 2 p.m.
I'll hand over this order also.
Especially fixed.
And I'm thankful to him, Lord.
As specific.
So grateful.
May I have,
My lord, I am mentioning.
I only pray for any other date, not May, March, not 5th or 10th, because I have.
March you will not get. It is only I think
My lord,
after 20th April.
My lord,
Any other date, my lord, because I can't, my lord.
So you it is not listed, na?
My lord, it is, I have the order, my lord. I'm mentioning on notice.
Give that.
It should be.
Who is for the other side? Nobody is
But
there.
Mr.
Mr.
Quintilius is
Quintalius,
appearing.
you do one thing.
Excuse me.
I taken note of it.
Madam.
I will adjourn the matter and fix appropriate date on the date fix.
I'm very deeply obliged.
my lord, I am mentioning a matter.
Send your junior.
I'll do so. I'm
My
very
lord,
grateful.
my lord, I am mentioning a matter. Your lordship can see.
Give all the mentioning to my court officer.
Oh, this is my lord.
If I will hear all the matter, then till
This is-
4:30 I will
No,
take
no,
the
it is
mentioning matter.
unusual. My lord, the contempt rule has been issued directing the contempt not to appear in person. my lord.
Ah,
I am praying before your lordship, my lord. Let them allow me to take part in the video conference, my lord, your lordship. All the officers, my lord, I have stated
when it is fixed.
on tomorrow at 2 p.m.
What you are why your officers are shying to appear before this court in person?
No, this is first time, my lord. This is
Maybe,
yes, my lord.
but the court is found that it is
Yes,
a,
I know, my lord. Let them, my lord, your lordship. The rule has been issued.
but you will not comply, but you will appear.
No,
Very
my lord,
good.
Only they will take part in the proceeding, my lord, contempt proceeding virtually, my lord. Your lordship kindly allow my prayer, my lord.
Okay, let it come.
Slightly sensitive.
Come, I am not recording. Let come appear in person. You inform this court. I will take.
Slightly sensitive.
I have stated let he appear. Let all the person appear through video conference.
Slightly,
Personally, or video conference, my lord. Oh, great.
slightly sensitive, else I would have handed the slip. 74-year-old man suffering from cancer. But the sole source of income is for a lot of property let out to SBI. They have stopped paying rent for 4 months.
Who?
But SBI.
Ah.
But in this street, I'm only seeking a lot that they at least resume paying the monthly.
So you left the civil suit. Now you are filing the civil suit by way of
But
writ application.
I'm covered by decisions. I will satisfy you. State Bank, my lord, basic, my lord, rent they must pay, my lord.
Hmm.
I'm not, my lord, claiming any mean profit or any damages.
Hmm.
But contractually, my lord, there's an agreement, my lord, what they are supposed to pay, they must pay. And I will cite decisions, my lord, that on contract, my lord, terms also,
Hmm.
my lord, a writ, my lord, is maintainable if it can be adjudicated without going into oral evidence. Lord, I will satisfy, my lord.
Okay, let it be listed as.
My lord, under compelling circumstances, my lord, I am mentioning,
You
my lord.
give all the mentioning list to my court
My lord,
officer.
my lord.
I will not hear any person.
My lord, this is the fourth
My lord,
time,
extreme
I am
urgency, my lord,
mentioning-
Honorable Supreme Court
My
judgment.
lord, my
violated.
matter is extreme
Please,
urgent matter, my lord. My lord, fourth time I am mentioning, my lord.
You have checked the diary.
My lord, last, yes, my lord.
You
I have
checked
checked
the
that.
diary when the date
Then,
is fixed.
then, my lord,
date
I
is
shall
fixed.
try my luck to another bench, my lord.
Have you checked the diary of the court officer when your date is fixed?
কি বলছেন?
When you mention the matter.
My lord, last, my lord,
Have you checked thereafter you check the diary of the court officer? Have you checked the diary of the court officer when your matter is fixed?
No, my lord.
Then you check first. I already given the date in my diary. You checked from the court officer.
My lord, it
My
is
lord, in my matter, my lord, a date
Lord,
has been given.
Honorable Supreme Court judgment violated by Calcutta High Court judges. This matter, this matter,
I am not taking any mentioning matter. All the mentioning be given to my court officers. I will see if the court find that the reason is good, I will
This
allow.
matter-
If it is find the reason is not good, I will not allow.
My
And
lord,
you
only one.
Take the date from my court officer on tomorrow and Monday.
this matter,
My lord, only
neither
one
a single
indulgence, my
bench,
lord. My
neither
my
division bench.
mentioning was allowed on the
Give the
last
mentioning
week of
list.
January, my lord. My lord, on the last week of January, my lord, my mentioning was allowed, my lord.
Your Lordship.
And the date was fixed on 3rd of February.
It was
Yes,
fixed
call
as
the list.
item number 52, Your
My
Lord.
lord,
Call the list.
my lord, kindly allow, my lord. My lord, my mentioning was allowed on the last week of January. The date was fixed on 3rd of February, my lord. Matter was never taken up, my lord.
Yes, who is the petitioner?
My application
When the matter was dismissed.
the matter was dismissed on the 13th of June 2025, Your Lordship. On the said day, Your Lordship, there was some road impediments as a result of which, Your Lordship, I was the arguing counsel. I could not come to court. And Your Lordship,
What is the matter?
Your Lordship, this is for Your Lordship. The main matter is with respect to the HPCL, who happens to be the respondent number 1, is operating a petrol pump on my land without giving any dues. Your Lordship, with respect to the dues aspect, this court I cannot approach with respect to the outstanding dues. Your Lordship, my humble submission today is, Your Lordship, let my representation be considered, Your Lordship. I have preferred an application under the Right to Information Act. Your Lordship, no information has been
To whom you have made a representation? SPIO.
SPIO.
Then you
Lordship, then-
file an appeal.
I have filed the appeal. The
Where is the appeal?
appeal, Your Lordship, will kindly find at page number. No, it is not. Appeal. It is not. Lordship, the first representation, Your Lordship, is at page number 24.
Where is the first application?
Subsequently, Your Lordship, will
Where is the application to the SPIO?
Your Lordship, I will just indicate that. Your Lordship will kindly see the reply of at page number 27 with respect to the Right to Information Act. Pursuant to that, page number 29 is my appellate application. Lordship will kindly see the date 12th of June 2023. All I am praying for, Your Lordship, is the direction upon the appellate authority to consider my
What is the 27?
27, Your Lordship, is the Your Lordship, to the SPIO I made a right to information application. Your Lordship, over there a response is furnished to me which is inadequate. With apropos that, I prefer an appeal under the Right to Information Act.
Where is your appeal?
Appeal, Your Lordship, will kindly find at page number 29.
What is the question with regard to your information? Where is the question?
Your Lordship, with respect to Your Lordship, will kindly take up page 29, 1B. Your Lordship, the copy of the license agreement and the permission on the basis of which the NOC has been furnished. Lordship, with respect to that and the aspects of the land, because Your Lordship,
Sir, where is your application under RTI?
Your Lordship, the RTI application, Your Lordship, will
Where is your application under RTI?
Lordship, I will just furnish that. Lordship will kindly take up page number 24.
24.
24.
Yes.
24, Your Lordship. This is my representation. On the basis of that, Lordship will kindly turn over to page number 25. Accordingly, the following documents are asked for.
So this is the not a application, this is your
Your Lordship, bereft of the nomenclature, nomenclature, Lordship will kindly disregard. Ideally, the nomenclature ought to have been under section 6(1), Roman 1. That nomenclature is
basis
missing.
on which the land of my client is being used for running this outlet. These are the 4 questions.
Four
Copy of the
questions which
license
has been
agreement.
replied to, Your Lordship.
So where is the reply?
Reply is at page 27, which I indicated to Your
27.
Lordship.
We have the land agreement with the so and so so and so. First is answered. Then second, copy of the license dispensing petrol pump so and so document between principal under section 8 is
Which, Your Lordship, I am aggrieved, especially with the non-furnishing of the records, and with respect to Roman 5 at page number 28. With respect to from the available record, we found that your
just
client.
a minute. Come to point 23.
I apologize.
The which document has not been, which information not been given, which information has been given to you.
Lordship
Come
will
to the page 23 and compare with the 27.
I am doing that, Your Lordship. Lordship will kindly see the basis on which the land of my client is being used running outlet. This document, copy of the license agreement and the permission NOC of the concerned district magistrate be supplied based
So
on
one is given the answer as per the agreement.
that, Your Lordship. Your Lordship, with
Kindly come to the question number 1.
Yes,
The
Your Lordship.
basis on which the land of my client is being used for running the said outlet. Now answer. We have used the land. We have land lease agreement. So that's the answer is okay.
Lordship.
There's no problem. Now kindly come to the question number 2. Copy of the license agreement or and permission of NOC of concerned district magistrate be supplied based on which the said outlet has been functioning.
Which is
Where is
denied
the
under
answer? So copy of license, the
That is
dispensing petrol pump, dispensing petrol pump and licensing license agreement is fiduciary document between the principal and the licensee, and the denied.
would not take the nomenclature of a public document. 8(1) is sensitive document, not
Correct. Then
provided to me. Then, Your Lordship, copy of the order of conversion of the land.
a copy of the order conversion. Copy of there's nothing. Permission of conversion district magistrate copy not available with us. Okay,
Copy of,
that's
so Your
not
Lordship,
available.
These aspects I am aggrieved by. Also with respect to
And list of the names whom the rental land is being paid with what? List of the names whom the rental of the land.
because, Your Lordship, I have claimed to be bereft of the merits. I have claimed to be the recorded owner of the right, me along with my brother.
Record. The petitioner has filed the present application being WPA present application being CAN 1 of 2025, praying for recalling of the order dated 13th June 2025, wherein this court has dismissed the writ petition for default for non-appearance of the petitioner when the matter was called. The petitioner submitted that the arguing counsel was. Where is the
Lordship, you will kindly see paragraph numbers 2 and 3 at page numbers 3 and 4 of my restoration application.
क्या बोला? The learned arguing counsel was suffering for illness, due to which the petitioner could not due to which learned counsel appearing for the petitioner could not appear before this court, and thus this court has dismissed the writ application. Had the petitioner perused the materials on record, and this court find that the petitioner has shown sufficient cause. Accordingly, the order dated 13th June 2025 is recalled. The WPA number 6728 of 2024 is restored in its original file. Scan number sensations are disposed of. With the consent of the petitioner, the original and the writ petition is taken up for final disposal. This court find that the petitioner has made an application under Right to Information Act for supply of certain information by a letter dated 3rd March 2023. On receipt of the said application, SPIO has provided the information only with regard to question number 1, and with regard to the question number 2, 3, 4, and 5, the authority, the SPIO has not given sufficient reason, and according the petition has preferred an appeal before the appellate authority. In spite of receipt of the appeal, the appellate authority has not disposed of the said appeal and is still pending. Where is the appeal?
Your Lordship will kindly take up page number 29 It's
appeal
dated 12th of June 2023.
since the month of 12th of June 2023. Heard the length full stop. Consider the submission made by the counsel for the petitioner, peruse the materials on record. This court find that the appeal preferred by the petitioner dated 12th June 2023 is pending before the appellate authority of Bharat Petroleum Corporation Limited, but till date the appeal has not been disposed of. Accordingly, the petition is disposed of, directing the appellate authority to dispose of the appeal preferred by the petitioner dated 12th June 2023 within a period of 4 weeks after receipt of the copy of the order. WPS disposed of.
Grateful. So the affidavit of service
Affidavit
and
of service be kept with the
the notice
record.
that I have given.
Next.
Grateful to your lordship.
My lord, Ankit Suraka is appearing for the respondent number 5.
Yes.
Ankit Suraka is appearing for the respondent number 5. Due to personal difficulties, he is unable to attend.
Who is appear?
I am for the
What is the petition for?
application is for restoration, my lord. Recalling of the order filed within time. It was dismissed while it was in month list. The list had collapsed on 30th of June.
What is the writ petition? What is
Writ
the
petition
prayer?
relates to, my lord, non-payment of dues, my lord, which the work after issuance of completion certificate. My lord, in the similar subject matter, several orders have been passed by the coordinate bench. If your lordship permits me, I shall hand over the orders. Completion certificate appears at page 91, my lord, and thereafter I have
When
sent
the work order was issued,
work order was issued on 2020.
then
Thereafter, I completed
when the
work.
payment was made,
No payment has been made till date.
when the
madam.
completion certificate was
Completion
issued,
certificate, page 91, if your lordship kindly.
19,
91.
91.
91. Yes, ma'am. If your lordship kindly takes.
Hmm. 2022.
Yes, my lord. Thereafter, my lord, there are several correspondences. Even the authorities have written to the,
January 22.
and my representation is, if your lordship sees, my name is also mentioned. It is 7th of January 2022.
Yes.
And if your lordship sees, my lord, the second paragraph, I have completed the work, geotagging has been done, everything the authorities mentioned. And thereafter, my lord, one reference was also made before the concerned authority by the Assistant Registrar of Cooperative Societies.
Yes.
My lord, I am led by Mr. Ankit Sureka.
Huh?
I am led by Mr. Ankit Sureka. He is for the respondent number 5.
My
My lord, we have not yet received the CAN application till now.
My lord, I have served the,
That's the reason, my lord,
the
we have not
affidavit
yet.
of service.
one relates to writ petition, another application. Two applications.
My lord, we shall take instruction and
What instruction? Your authority is admitted.
My lord, on
my lord,
similar, out of the similar project, my lord, coordinate bench.
Yes, it is served. It is served. Can it
kindly
be
fix
served?
next date, my lord.
Why can? Why? Every day, why the list should be burdened? Once the matter is listed today. You see, I have seen the morning. Thousands of advocates are mentioning the matter and you are asking the time. Record an order.
And if your lordship, I have handed over the order. If your lordship,
The petitioner has filed the present application being CAN 1 of 2025. Praying for recalling of the order dated 30th June 2025, wherein this court has dismissed the writ application for non-appearance of the petitioner, dismiss the application for, dismiss the writ application for non-appearance of the petitioner when the matter is called. The petitioner submit that the matter was in the monthly running list,
Paragraph 3.
monthly running list, but all of a sudden the matter has taken up a hearing, due to which the learned counsel could not appear before this court and the matter is dismissed. Immediately, petitioner has filed the present application for recalling of the police. At the learned counsel for the petitioner, this court finds that the petitioner has shown sufficient cause for non-appearance of the petitioner before this court when the matter is called on 30th June 2025. Accordingly, the order dated 30th June 2025 is recalled. And WPA 18667 of 2024 is restored in its original file. CAN number 1 of 2025 is disposed of. Learned counsel for the respondents press for time for taking instruction with regard to the writ application. Accordingly, for the interest of justice, the case is set down. Let the matter appear on 18th February 2026 under the heading urgent motion. It is made clear that on the date, if the respondents fail to come with the instruction, the appropriate order will be passed. Next. Yes.
This matter I am appealing on behalf of the petition.
Who is for the petitioner? You. What is the contempt?
Is my lord directed to give correction with assistance of the police.
Huh?
Learned friend clients, electric supply corporation gave notice to have the inspection and give connection. What happened after getting the information, the private respondent will lock the door. Well, if I go there without police, well, there will be an awkward situation, even I am state of death. Well, so what I am saying at this stage, in fact, due to the disturbance created by the private respondent, they are not in a position to give connection. So what I am praying at this stage, my lord, kindly direct the police authorities to, my lord, open the padlock so that they can inspect and have it the connection, give the connection. Without that direction, there will be
How in the contempt application direction can be passed?
The last paragraph of my lord's order.
Where is the order? Where is the order?
Already at the first page, it has been annexed to 24th, my lord, your lordship can see according to the inspector in charge. Second page of the my lord's order, paragraph 7. According to the officer in charge, Nandakumar Police Station is directed to provide police assistance to the officials of the WBCT. And at the time of the inspection of the premises and grant electric connection, it is clear that the fee of Sasana will be there.
Yes.
There is no other difficulty.
Yes.
Police has not come. This order was communicated. They also communicated that the date of inspection, police has not come. But taking that advantage, they locked the door. So they cannot have the inspection. I cannot get the electric.
Who is appearing to the WBADCL?
The last.
But I appear.
Yes. Whether you have
Lord, I have been informed over phone to appear. I am appearing, no copy. Contempt. Number one. Number two, my lord, they have not served yet. Number two, my lord's order was very clear. After compliance of all formalities, within 4 weeks, we have to give connection. But compliance includes, my lord, inspection. Compliance, my lord, includes payment of, my lord, quotation. Compliance includes, my lord, wearing, internal wearing, and, my lord, completion certificate.
Correct. Whether you inspected the premises?
No.
That's why.
That there's, we cannot proceed at all. Because it is under lock and key.
Okay, you saw the copy, you filed the report. The petitioner has filed the present contempt application on the allegation of violation of the order passed by this court dated 2nd December 2025. Petitioner is directed to serve the notice upon the alleged contemners. Who are the contemners?
That's the, my lord, that it appears.
Of the alleged contemners by Who is these one, whether you have issued the police authority? Where is that? Where is the contempt now?
Here, police has been made party.
Where is that?
But it is appearing on the first time. So your lordship kindly direct me to serve the copy upon the.
To the alleged contemptors within a week.
On indulgence, I am saying that your lordship kindly permit me to add the private respondent as a party here also.
You're not.
Otherwise, unless he is present, there may be difficulties.
Milord,
Let me see the police.
one exception I will be taking, Milord. It's a matter of the supply, concerned supply where Kohinoor Ali might be involved.
Huh?
But he is Kohinoor Ali, the contender number one. I understand, Milord, he is to reply or say. But what about the chairman? How is concerned with this, Milord, the contempt matter?
Okay, you take exception. क्या बोला? Is directed to serve the copy of the contempt application to the alleged contemptors within a week from date. List the matter on 23rd February 2026.
If you are going to supplementary execute that document, the notice, let it be.
What?
No, no, supplementary, after filing of the contempt. Repeat that two documents hasn't been annexed. I have prepared a supplementary, kindly permit me to file it. And I will serve.
Supplementary affidavit filed by the petitioner will capture the record. The petition also directed to serve the supplementary affidavit to the alleged contemptors. Yes. Next.
My Lord, 23rd.
I will also serve copy of.
Second. 23rd, Lordship. Kindly make it, Milord, not make it 23rd, Lordship. 25th.
25th.
Well, I will serve upon the OC.
Grateful, Lordship.
Yes. Next.
That this is that insurance agent GEQD. Your lordship was pleased to pass an order directing the insurance company to bring on record or produce before this honorable court, my lord, the documents on the basis of which GEQD had filed their report. But
Yes. Are documents available?
Lordship, out of all the documents, we have received just the GUKD original report. Other documents are yet not raised, Your Lordship. We humbly submit for some more time, Your Lordship. This is a 20-year-old matter, Your Lordship.
That's why I propose. If all the document is there, I am fixing a time for allowing to examination of the witnesses.
no, let them, my lord, get the documents.
Some more time, Your Lordship.
Let them
and
get the
then they can be
documents.
done, Lordship.
May I have your lordship's kind leave, my lord?
Learned counsel for the respondent submit that he has got only the original GQD's
Report, Your Lordship.
report, but he requires further time to ascertain whether the other original documents is available are available with the department or not. In view of the submission made by the counsel for the respondent, the case is adjourned. Let the matter appear on 10th March.
Lordship.
Under
Much
the
obliged,
same meeting. Next.
That is that Chinese matter. Mr. Sen called me. One of his relation is in the hospital. He will be coming. Well, can I keep it at? No, can I give you a time?
1 p.m.
1 will be subject to my lord's.
Okay, 1 p.m. Come at 1.
Well, at item 8, I'm praying for a short pass over. Kindly fix it at 12:30. Well, Mr. Shopon Banerjee is there in this matter as respondent number 6.
Pass over. Next.
First one, it will be taken.
Well, kindly it could be taken on after 12, Your Lordship. Kindly it could be taken after 12, Your Lordship.
1:30.
1:30.
Ready? 1:30. Ready?
Well,
Have you gone through the cause side, the cause list? All the matter is fixed. As per your advice, the court cannot fix this time, that time.
The last occasion, Lordship, the petitioner has been directed, Lordship, to provide the copy. Let the matter be start, Lordship. Because
yes.
I am appearing for the state respondent, Lordship.
What is the matter?
For the board.
No, he's for the marketing department.
Remind your lordship, this is matter related to the Kaju nuts.
Yes, marketing.
Yes, marketing.
Yes.
Kaju nuts.
They have to be heard. State has to be heard.
Hello?
State is to give the reply.
State is there. State.
Mr. Banerjee is for the board, marketing board.
You are appearing for
Not for the state respondent.
state respondent.
Not
Okay, let them complete. In the meantime, they will. Yes. When your Banerjee will be appear?
Well, if Your Lordship. Well, before 12, if Your Lordship kindly.
So let you take note of it. Let them continue. You take note of it. Yes.
My lord. Now, my lord, I see the matter was argued at a length. Now, my lord, my specific case is that we are the processing. Now, my lord, we have imported the kaju raw materials, my lord, from the outside of the India and from the state of the outside of the West Bengal. Now, specifically, my lord, the marketing committee is arbitrarily levying fees, my lord, only though no transaction has yet been effected within the area of marketing. Now, my lord, I moved the writ petition before this honorable court. The court passed an order, page 23.
Correct. You are. You taken note of it. Yes. What?
Yes. Thereafter, my lord, inspection was done.
Hmm.
I see the inspection report at page 25.
For
Page 25.
page 25.
They have said only one transaction has been taken place within the area of marketing.
Page 25.
Page 25. In my writ petition.
Yes.
Now, we can see the Sonjeev Kaju processing of village Sassan Sir is a Kaju processor, and it is mentioned in the aforesaid order of the Honorable High Court Calcutta on the Challan, and attached hereto it is evident that on 31st March 2024, Mr. Sonjeev Kaju purchased 12,700 kg of Kaju nuts from the trader named Daud Kaju nuts. Only this transaction has been taken place. There are no other transactions which have not been taken place. Now, that's why they have said that we are liable to pay the levy as per section 17(1) of the Agricultural Produce Act. Now, the final order was passed, page 35, relevant, page 35. This is what is page 35. Now, can see hearing both the parties and considering the
Page 35.
Page 35. Hearing both the parties and considering the inquiry report, including the challenge and waiver as submitted by the
No such order. What you are reading? 35 is some notice. P4.
P4. 35.
Yes.
The invoice. This is my writ petition. Can you see the writ petition?
Yes, I am in writ petition only.
Page 35.
Now, can you see page? In my supplementary affidavit, I have also annexed. In my supplementary affidavit.
Supplementary affidavit copy, we have not got the copy.
Yes, I am reading that. You have received it. But
Lord, we haven't got the
page
copy.
244. Page 244.
Oh, yes.
The order has been annexed.
Page 35 of supplement.
Page 244. Actually, what it? Can you see the order?
There is no page 244 in the supplementary.
The order.
There is no 244 page in the supplementary affidavit.
Yes.
Yes, what is? You are telling the 244 of the supplementary affidavit. There is no 244 page. See.
There is no such thing. Supplementary affidavit দেয়নি আমাদের আমাদেরকে দেয়নি
I am giving the copy of this order.
Record an order. The petitioner has referring the pages from the writ application, but this court find that the pages is not telling, which has been filed before the court. Accordingly, petitioner is directed to correct the page number of the writ petition as well as correct the page number of the supplementary affidavit within 2 days from date. List the matter on.
My lord, I haven't received any copy yet.
On. This is the matter on 19th February 2026.
My lord, kindly direct them to serve me a copy. We haven't.
Serve the copy. The petition is directed to serve the supplementary affidavit, copy of the supplementary affidavit to all the respondents.
Yes, much obliged.
Next,
Well, out of within 5 items, you pass this order on the earlier occasion.
it will be there only. Don't worry. Under the same heading, you have recorded. What can be done, sir, when the matter is listed? You have not come with the prepare all the documents.
This matter actually, you should know that.
Yes, call the other matter.
But this will be coming under the heading urgent motion.
Urgent motion.
But this application is a revision out of a conviction.
Yes.
This application is out of a revision. Is a revision out of a conviction, my lord. My lord, 5 appellants, 5 petitioners are before your lordship. Out of the 5 petitioners, my lord, Arjun Singh, petition number 4 has expired.
Arun Kumar.
My lord, Arun Kumar has expired. My lord, the petition number 2, Arjun Kumar, was convicted under section 448 of the Indian Penal Code and sentenced for 1 year. For the offence 436 by 149 of the Indian Penal Code, 7 years. And for the offence, my lord, 427 by 149 of the Indian Penal Code, 2 years. The other appellants, that is PW1, I'm sorry, yes, PW1, PW3, and PW5. Fourth one,
Petitioner.
Petition number 5.
Now, petition number 1 is convicted.
One is have been convicted on different heads. One was convicted for valor.
No, but the problem is that you are having the total because lower court record is the trial court record.
Yes,
is not
that
here.
is what your lordship on the earlier occasion directed.
On the last occasion, my lord wanted that
Since only the copy of the judgments have been annexed, not the evidence.
You not disclose only. You are having.
Caesar list my lord were required, my lord.
Yes.
Caesar list were not with us.
By an order dated 21st of November 2025, this court directed the department to call for the trial court record. But it is found that till date the trial court record has not been called for. Accordingly, department is directed to take appropriate steps to call for the trial court record by the next date fix. List the matter. Which court it is? Which court? Trial court?
Purulia.
Purulia.
No, trial court ke bolo, trial court.
Trial court is at Purulia?
Yes, my lord. Trial court is at Purulia.
Purulia. List the matter on 17th March 2026.
17th March.
Time be fixed for at 2 p.m. my lord.
I will take the no problem. That's
One
why
more request, my lord. May I, if you do not take me amiss, my lord. But some matters, my lord, were fixed, my lord. We have mentioned the matters.
First, you go to the bar, take the meeting. If all persons are coming, thousands of people are coming for the mentioning, what the court will do?
My lord has got nothing.
So nothing can be done.
Understand, my lord,
If
my lord.
you persons are doing like this, all the persons of the thousands people are mentioning the matter, whether the court will the whole day, whether the court will take the mentioning
That is
matter.
humanly possible, my lord.
So then you talk to the bar, you fix a scheme how the matter is to be mentioned. Otherwise, I have fixed my scheme. Whatever the mention, I will take, and I will take all the mentioning list in my chamber. I find which is the urgency. I will
I
attend
will write
accordingly.
it down, my lord. Where is the urgency?
Yes, you mention the urgency. I will take.
I'm grateful.
I'm appearing on behalf of the petitioners, my lord.
Yes.
Affidavit of service.
Yes.
My lord, both the petitioners are husband and wife, and they are leading a happy conjugal life for the past 24 years. But they have been unsuccessful in procreating an offspring. So they have approached the Spursha Infertility Clinic. But they have been turned down because the petition number 2, husband, is over age. In the view of the relevant provision of the Art Act. After that, my lord, they have approached a health department for a necessary permission, but no such permission has been accorded to the petitioners, for which the petitioners have come before this your lordship, honorable court, my lord. My lord, on same circumstances, a coordinate bench of this honorable high court pleased to pass an order allowing assistive reproductive technology service in WPA number 23776 of 2024. My lord, this is the order. Identical order, my lord. So my humble prayer is, my lord, before your lordship, is the petitioner should be allowed to avail the art services so they can get blessed with a child, my lord.
Yes.
Though my lord 21, I think 21G is barred, but my lord, the coordinate bench also passed in defined cases. My lord, 1 minute supporting 2024 0 AIR Cal 163. Yes, I'm showing. Of this honorable court, this is also in his favor. In his favor. So may I show?
Yes. So what is your contention?
Actually, the age of the petitioner,
Correct.
number
It
one.
is admitted. Husband is the overage, wife is still in the age. So what is your contention?
Well, if my lord, so I have no objection, my lord. If the health department is allowed, if the health department is allowed by the lord, by lordship order. So in that case,
So you will not make any submission.
No, my lord. Because my lord, already there are 2-3 judgment is there in the High Court, the same issue. In this matter, the age of the husband was 58 years, and the wife probably 48 age. So justice supervisory was allowed. So my lord, in the coordinate bench, and the matter not yet challenged before any
The
division bench.
petitioner has filed the present application praying for permission to avail assisted productive technology to IVF procedure upon obtaining sperm and ovum from concerned bank in terms of the provisions of the Assisted Productivity Regulation Act 1921. The petitioner submits that the petitioner number 1 and 2 are the husband and wife, but they are not blessed with, they are not having any issue. They have not issue. They have no issue. Issue.
No, my lord, no.
No children.
No children, my lord. They have no children.
But kya bola? Blessed with any issue out of the said marriage. Full stop. The petitioners have.
May I offer the judgment?
Petitioners have approached when you approach, where is your averment? Nothing.
Yes, my lord, it's there.
What is that?
My lord, page number 32.
No, in your averment. Approached the consulting medical expert and have decided for availing assisted productive technology through the womb and sperm donation. The petitioners have approached Isprasha Infertility Center in the month of December 2025 for obtaining benefit of assisted productive technology, and both the petitions have been duly medically examined, but it was found that the petitioner number 1, the husband, is petitioner number 2, the husband is aged about 55 years. Where is the act? You are having the act? What is the age of the husband?
My lord, right now 56.
And what is the age of the wife?
Wife is 49.
48 plus.
Kindly come to the your cost letter. You are junior persons. You're not preparing the brief and coming to the High Court.
My lord, I'm so sorry, my lord. Inadvertently mistaken, my clerk has written the age of the wife, but there is a
Clerk has written and you are mentioning the arguing the court.
I'm so
Why
sorry.
you are not allowed the clerk to come here?
I'm so sorry, my lord. But the age certificate is proof age of certificate is, my lord, in page number 21. I went next. 21 and 22. 21 for wife and 22 for husband. Age proof.
Where is that?
My lord, annexure P2, page number 21.
That is the Aadhaar card, election card.
And 23, my lord, West Bengal Educational Secondary Certificate, which show the age.
77.
Yes, my lord.
But may I leave my junior is here? May I leave my junior? I'll leave.
क्या बोला? Aged of petitioner, husband is aged about 55 years.
No, my
58 plus.
58 years. And the wife is aged about
40.
Petitioner, husband 56, not 58, 56.
You do one thing, come tomorrow with paper. It is found, I am not writing, come tomorrow with ready. Yes, next. Not today.
My lord, I'm so sorry, my lord. And I'm praying for liberty to correction the mistake, my lord. I'm praying for the liberty to correct the age.
Madam, you are appearing in the High Court. Be careful.
I'm so sorry.
In the how you written the 50 in the after the affidavit.
58, actually pretty,
Kindly see the cost title. What you have written. Tomorrow, if tomorrow the authority will challenge, the court will be in the problem.
I'm so sorry, my lord. I'm so sorry, my lord.
Petitioner given liberty to correct the date age of both the petitioners in the writ petition. Let the matter appear tomorrow. Yes. Next.
Well, at this matter related to an application for shifting that was preferred by a
Shifting
Pochai
of,
and
shifting of?
of a Pochai and country spirit shop.
Yes.
Well, the shop was operating since 1960 at its licensed site, but due to an order passed by the Honorable Supreme Court on 15th of December 2016, whereby all liquor outlets which were situated within a distance of 500 meters from the national highway and the state highways, they were directed to be closed down and had to be shifted.
Correct. You argued the
Yes,
matter.
on the last occasion, I have argued the matter.
Yes.
My learned friend is here. Well,
yes.
Well, there are two aspects in the matter. Initially, it was a restricted free zone when he was granted the license. Subsequently, due to the interference of the Honorable Supreme Court and laying down certain guidelines, it came into the zone of a restricted. Again, it became a restricted zone. He was asked to shift to a place. He did not shift. He was doing his business from another place. Action was taken and was compounded subsequently. Now he wants to go back to the original position. Now what would be once there it is an admitted position, the Honorable Supreme Court has relaxed certain criteria. But question is, my lord, whether once it became a restricted site, whether a further examination would be required or not. If my lord sees the definition, 2 or 3 definitions.
What is the concept of the existence site?
That is site, new, there are 3 definitions. Site, new site and existing site. But I'm giving the same book because so I can tally the pages. The act.
Yes.
My lord, Act is still page 60. Page 60 is the Bengal Excise Act, and the rule starts from thereafter, my lord.
Yes.
My lord, we are concerned with first, my lord, the West Bengal Excise, the first rule, page 1. 2002, 2000.
Bengal Excise Act.
The rules, my lord, 2002 rules.
It starts from?
Well, the first page, my lord, after this page 60, my lord, the acts ends. The rule starts thereafter. The first rules, my lord, page 1. West Bengal excise selection of new sites and grant of license for retail of retail sale of liquor and certain other intoxicant rules.
2003.
My lord, would kindly see first the definition.
No, yeah, I think there's some different. Which
page 3, my lord. May I find it, one? Page 3, one.
Yes.
First definition I want to take, my lord, 2 Roman 12 site. Site means any place in a local area, preferably in a marketplace, commercial center, or business area. Site. My 2 Roman 12, my lord.
2 Roman 12. 2 Roman 12 or 3? 3.
3. Oh, 3. Yes, my lord. I attended.
3.
I attended. Apology, my lord.
3 Roman 12.
Yes.
Site.
Yes. So, my lord, now, my lord, kindly the previous page, Roman 8, new site.
Site means a place in a local area, preferably in a marketplace, commercial center, or business area.
Yes.
Correct. Then,
my lord, the previous page, 3 Roman 8, new site.
3 Roman 8, new site. Yes.
Means a site other than an existing site. So all other site other than an existing site. Now, my lord, we go back to the original 2 Roman 3. Existing site means a site for which a license has been granted under section 30 or is required to be granted under section 31 on the expiry of the license granted under section 30, as the case may be, for retail sale of liquor or in any other intoxicant specified in sub-rule 1 of rule 2. A site for the so and so on, this is not required. The explanation part which my learned friend is relying upon. An existing site shall continue to remain an existing site even if retail sale of liquor or any other intoxicant specified in rule 2 under a license is stopped or closed from the existing site for whatever reason for any period, or even if the license is cancelled, suspended, or withdrawn or surrendered, or even when the licenses lapses on the date of persons to whom with or without other it was granted. My contention, at least I'll try to convince my lord, this stoppage, closure, surrender, suspension has to be in terms of the statute. Supreme Court order honorable created a new class where the restriction was again implemented, which was not contemplated. So this provisions or this eventualities for it to continue as a existing site
shall continue to remain
an existing site. I'm giving example. Kindly see section 26, just section 26, which is at page 22. Page 22.
Yes. Power to close shop.
This is the closure. Under the statute, my lord, it has to, this closure, stoppage, withdraw, it has to flow from the statute itself. Supreme Court's order, my lord, I'll show the judgment. With Supreme Court's judgment, it was a new terms and condition was put into.
Yes.
So existing site, my lord, my contention would be once it became a restricted site, whatever the examination or analysis that was required, it had to be undergone again. My lord, kindly see 26. Now kindly see 42, section 42.
Yeah.
Yes.
Yes. Power to cancel or suspend.
My power to, again, my the languages, my lord, I'm just trying to show the language. My lord, suspension, withdrawal, these are the words used in existing set. Now 43, power to withdraw license.
Yes.
Power to withdraw license.
Yes.
44, my lord, would kind surrender to license.
44,
section 44, my lord.
Yes. 44, bar to right to renewal.
Section 40, surrender of license.
Surrender, yes.
Surrender of license.
Yes.
Now, my lord, kindly see the terms used in that particular proviso. Explanation and tender apology, my lord.
Both
An
on the agreement.
existing site shall continue to remain an existing site even if retail sale of liquor or any other intoxicant specified in Rule 2 under a license is stopped or closed from the existing site for whatever reason for any period, or even the license is cancelled, suspended, or withdrawn or surrendered. But these are all contemplated under the statute. But as an authority, it is a well settled proposition. I cannot act beyond the statute.
Correct.
Any other normal person can do anything other than what is prohibited. So, my action, this suspension only flows from those provisions. Now, there's other provisions also, in the rule itself. My lord would find 111, page 111, my lord. Page 111 of the rule. Man, I'm just showing them, not showing just the provisions, the words, the closure, stoppage, where has been used.
Yes.
The West Bengal excise closure of retail licenses.
111.
Yes, my lord. The West Bengal excise closure of retail license premises.
Yes.
Right. When on the days, election days, when a sensitive areas, the excise commissioner has been entrusted or empowered to close those shops. My lord, my submission would be only this positions, only when this eventualities happens, which is in terms of the statute, only then it continues to be an existing site.
Yes.
It continues to be.
So your case is that it is your under which order is bar has been closed? By which order? Please.
I'm showing
by which order the bar is closed?
My lord, originally Supreme Court has passed this order, 2017. What I think it is. 17-2 SCC, my lord.
Yes.
281. Now kindly see page para 29. I'm not taking the entire judgment, but para 29. All the stalwarts appeared thereafter so that the liquor continues. I show that paragraph, Mr. From Sal 29. No.
I also had the privilege to appear.
My learned senior friend is a stalwart in this.
No,
field. I'll actually learn from him.
No.
We accordingly hereby direct and orders as follows. 29.1. All states and union territories shall forthwith seize and desist from granting license for the sale of liquor along national and state highways.
Yes.
The prohibition contained in para 29.1 above shall extend to and include stretches of such highways which fall within the limits of municipal corporation, city, town, or local authority. The existing license which have already been renewed prior to the date of this order shall continue until the terms of the license expires, but not later than 1st April 2017. All signage and advertisements of the availability of liquor shall be prohibited and the existing ones removed forthwith both on national and state wise. No shop for the sale of liquor shall be visible from a national or state highway, directly accessible from a national or state highway, situated within a distance of 500 meters of the outer edge of the national or state highway or of a service lane along with the highway. All states and union and territories are mandated or to strictly enforce the above direction. The chief secretaries and so shall within 1 month this was the direction. This direction issue under Article 142 of the Constitution. Now, my lord, this went to a change. Now, the next judgment is 2017, Volume 6, SCC 715. But this issue was revisited.
Yes.
But kindly see 5 and 6 is very important. But which are the states who had approached and which are the states who did not approach? 5 and 6. For convenience of reference, we may indicate that 8 states have moved this court in the present proceedings.
Yes.
The states which are before this court are so and so. We may indicate the following states have not finally applications. West Bengal, my lord, would find 18, paragraph 5.
Yes.
Now, my lord would kindly come to straight away, paragraph 18.
Paragraph
18, my lord.
Yes.
The submission of the Attorney General and of other learned senior counsel who adopted the same line of argument which is based on the state excise rules is lacking in substance. The state excise rules contain enabling provision. They provide for a discretion for the grant of liquor licenses. No individual has a vested right to obtain a license. There is no fundamental right to carry on business in liquor since as a matter of constitutional doctrine, Article 19(1)(g) does not extend to trade in liquor which is consistently regarded as res extra commercium. When an excise rule which has been formulated by a state government provides for the maintenance of a specified distance from an institution or amenity, that the postulate is that no license can be granted at all by the state government within that distance. The state has a discretion on whether a license should be granted under its enabling powers. No individual can assert a right to the grant of a license. Trading in liquor is a privilege conferred by the state. The directions which have been issued by the court do not breach any norms in the nature of prohibition, nor they operate to lift the prohibition imposed by law. The effect and purport of the direction is that in the interest of public safety and public health, the distance from the outer edge of national or state highways or a service lane along with the highway is to be maintained of 500 meters. This does not amount to an assumption of a legislative function by the court. In fact, the requirement of maintaining a distance from highway ensures that the prohibition on the grant of licenses along with the highway is not defeated by the presence of outlet in close proximity to the highway. The maintenance of an adequate buffer is a necessary incident of the principle which is to prevent ready availability of liquor to users of a highway. In any event, no private individual can be heard to make a grievance of the prescription of 500 meter, which is manifestly in public interest. In the teeth of thereafter, all the submissions. Now kindly come to my lord, para 24 and 25. Another submission which has been urged on behalf of the applicant is that the expert committee appointed by this court, chaired by so and so, has recommended distance of 100 meter with reference to highways. In view of the recommendation has been submitted that this court ought not to have fixed the minimum distance at 500 meters. We find no merit in the submission. The recommendation of the committee cannot be are placed on a higher footing than what it purports to be, namely a recommendation. The opinion of the expert committee was duly cited before this court during the course of the proceedings leading up to the judgment dated so and so. 15 December is the first judgment, 17-2. We are of the view that a distance of 100 meters with reference to the highway is not adequate to ensure that users of the highway do not seek access to the sale of liquor in close proximity to the highway. A distance of merely 100 meters will not serve the purpose which is sought to be achieved. Hence, we have not accepted that part of the recommendation of the committee, but have considered it appropriate to enhance the minimum distance. After considering the submissions which have been urged before this court, we are of the view that there are three areas where the rigors of the directions which have been issued by this court may require to be suitably modulated without affecting the basic principle underlining the judgment. The first is in relation to the limits of local bodies with a population of less than 20,000 people. In such areas, it has been urged before this court that a state highway is the main thoroughfare along with the township has developed in small clusters of 20,000 or less. Hence, the requirement of maintaining a distance of 500 meters from the outer edge of the highway service lane may result in a situation where the entire local area may fall within the prohibited distance. We find some substance in the submission. We must emphatically clarify that even in such areas falling under the local bodies with a population of less than 20,000, no license for the sale of liquor should be issued along with national or state highway or services lane along with the highway. Similarly, the sale of liquor should form a point which is neither visible from the national or state highway or which is already accessible from a national or state highway. However, in such a situation, the prohibited distance should in our view be restricted to 220 meters from the outer edge of the national or state highway or of service lane along with the highway. We accordingly direct that the following paragraph shall be inserted after so and so, so and so. But certain restrictions were relaxed. Certain
Correct.
restrictions.
220 it has come. 500 to 220 it has.
Now, question would be, my lord, putting in a restriction whether comes in any one of the eventualities that is mentioned in the explanation. According to me, my lord, it was not a stoppage. It was not a closure. It was not a withdrawal or a cancellation or suspension. It was simply a new eventuality was contemplated, was inserted by way of legislation which was not contemplated in the explanation. My lord, whatever there are four words: stoppage, stopped, closed,
cancel, surrender, withdrawn.
These are not the eventualities that is found in this judgment, my lord. This was implicit a new restriction to safeguard the public. Now, my lord, what happens?
No, that's why. Okay, this is Supreme Court judgment. This is the law. What your authority has done with this license?
My lord.
What order has passed by your authority?
My lord, would kindly come to page 27, the facts. Page 27.
Yes.
Because this would be the first point on this issue. This, with my little experience, this has not been decided what will happen after Supreme Courts. Because when restriction free, it became a restricted free. No, first it became a restriction. Then it becomes a restricted free. Whether restricted free would come within the definition of explanation, existing definition. First one. The appellant, 27.
Yes.
The appellant, Sri Purnachandra Mondal, attended the hearing through virtual mode. His legal counsel, so and so, appeared physically before his forum. But I start for the appellant is the holder of the excise license for retail of pochai for consumption of and or on the site operating under the name and style as Chondi Pochai.
That's the fact, whatever it is.
The licensed ester was originally the site became a restricted one. I'll start with from.
Yes.
Subsequent to the judgments passed by the Honorable Supreme Court of India in connection with civil appeal number so and so, prohibiting functioning of any liquor vents situated within a distance of 500 meters from the national or state highway. The appellant submitted a prayer for shifting to a new site situated at so and so at plot number so. Since the offered new site was found to be a restricted free site in terms of Rule 8 of the new site rules, the prayer was approved and communicated to the applicant with a memo number so and so. The appellant, however, conducted business from a site other than the approved one. The violation was detected by the district authority and a miscase was initiated against the appellant. The same was compounded for an amount of so and so, and the appellant was directed to submit prayer for shifting to another suitable site within a period of 2 months. The appellant prayed for shifting to the previous site of Chandni Pachwai and so, the site from where the license operated prior to the judgment of the Honorable Supreme Court of India. The prayer was rejected upon finding that the offered site to be a restricted one, and the license was suspended vide order dated 11th October 2022 by ADM so and so. Being aggrieved by the order, the instant appeal was preferred. The appeal was submitted after the expiry of the statutory limitation period. However, the appellant explained the reason for such delay and prayed for condoning the same. The prayer is allowed and the appeal is taken up for hearing on merit. The appeal was initially heard on 12.
Now you come to this. Honorable Supreme Court of India, the prayer for rejected of filing the offer to cite the restricted one was suspended. Which order was suspended? 11/10/2020. What is the order?
Because he did not shift to the place where he was required. First, when the Supreme Court's order came, so he was asked to shift to some other place. That shifting order is at page.
That order I want. No? After the Supreme Court order, what
page 25, subject to correction, 25.
Page 25.
No, sorry, madam.
23.
23.
23,
madam.
Yes. Approval the proposed shifting of census and existing proposal.
And no fees was charged because madam, it was something pursuant to a direction of the Honorable Supreme Court, so no fees is charged. Otherwise, fees are charged.
Yes.
So, this was the approved new site. One was the existing, one was the approved new site.
From existing site to proposed new site.
Proposed new site.
Correct.
Well, according to the allegations, he did not move to that subsequent site.
That is
not an issue. That is not an issue.
That is condoned by you.
Yes, absolutely. That is not an issue here. Yes. That cannot be an issue. But I go back to the.
So after the Supreme Court judgment, you have given the allow for shifting for the
to any
alternative site.
Other site.
To the alternative site.
To an alternative portion, not to the original position.
Correct.
Not to the original. But that is the stand. The explanation is, if kindly see the 29 last paragraph. The explanation is this. I cannot possibly improve, but my contention would be,
yes.
Two intrinsic components of an excise license is: one, the person to whom the license is granted; second, the site from whom the license shall operate. When the person holding the license is replaced by another by way of transfer of license, the previous holder relinquishes every right to carry on license henceforth. Similarly, when the license shifts to another site, the previous one cannot continue to remain alive, thus assigning multiple existing sites to a single license. A plain reading by a person of ordinary prudence ought to comprehend the position. The undersigned is of the opinion that this may have been the reasoning for not including instance of shifting within the explanation as to when characteristics of an existing site remain unchanged. Therefore, for shifting of the license premises of so and so, the site offered by the appellant had to go through the recurse of new site rules 2003 Supra, which in the present case was established as a restricted one beyond doubts. Hence, the undersigned does not find any anomaly in the order so and so.
Okay.
And this was affirmed by the state authorities, the additional chief secretary, which starts from page 32. Now, my lord, would find just now kindly see rule 9, man. Rule 9.
2003 rule.
2003. Subject to such instruction as may be issued by the government, state government, or excise commissioner from time to time, if the collector is of the opinion, having regard to the general trend of consumption of liquor and other intoxicants specified in sub rule 1 of rule 2 in a local area or its adjoining area, that it is necessary to grant license of any number and any category referred to in clause A, so and so C to M, and this falls under 4D. This falls under 4D. That my lord would find Pochai is under 4D. Page 4, 4D. Pochai is for 4D of that rule, my lord, of that rule only. My lord, page 4 of that rule.
4D.
Yes, my lord, Pochai.
Pochai for
Pochai or consumption is 4D. And this C2M, it falls under
no,
this.
subject to the instruction, maybe so and so, so and so. Opinion having regard to the general trend of consumption of liquor other than the intoxication. Yes.
C2, but it falls under this to meet the demand of such area.
Correct.
So, my lord, what my learned friend today says, this explanation or this inquiry by the collector is no more required because it has already been considered as an existing site at the time it was granted. But this to come out. And another contention, if one is Rule 85, Rule 85, I'm giving the exact page number, my lord. Rule 85. Page 410, my lord. 410 of the rules.
60.
59.
59.
50?
My lord, this is Rule 59 of consolidated rules made under Section 85 of the Bengal Excise Act, which is at page 410. 410.
Yes.
The number of licenses which may be granted for any local area shall be regulated by the needs of the people of the area. No license for the sale of any other intoxicant in any local area shall be granted unless it is required either to meet as ascertained demand for such intoxicant or to counteract supply through illicit sources, provided no license in excess of the total number of licenses which are forced in an item during the previous or for the so and so shall be granted. So, my lord, local need is one of the criteria which is to be considered at the.
That is not the criteria you rejected.
But it is, my lord,
that is not the ground you have rejected.
No. But I cannot improve on the reasons. But I cannot. But my only explanation today, my lord, would kindly consider. The Honorable Supreme Court did not make it an existing site with deepest respect. These four eventualities, these 4 or 5 eventualities that is contemplated under in the explanation was something has to be in terms of the statute or within the 4 corners of the statute. This restriction, imposition of
Correct. So now the only the question, see, the petitioner was running the liquor shop in a particular area. Correct. And continuing, you are allowing, extending the or renewing the license from time to time. It is not your case that the license was cancelled, suspended, or withdrawn, or whatever. It is for violation of any rules and all this. No. The only contention is that due to the Supreme Court order, initially ordered 2017, first order is a 500. So in compliance of the order passed by the Honorable Supreme Court, where there was a direction upon the Chief Secretary and all the state authorities, so immediately has been given shifted to the or given the alternative. Leave aside the shifted, given the alternative place. And he went there, but he is not in the alternative place. He was another place. It was when the inquiry was conducted, fine has been imposed. Subsequently, fortunate and unfortunate, whatever it is, the 500 has come to 220. Correct. So his license was there prior to the Supreme Court order. Now, if it is taken into 220, cannot be taken as existing.
My lord has also have to consider the subsequent development. The schools have come up.
That is
the contention. That is what we kindly consider this. If after 12-15 years there is a change of law, in the meantime, ultimately is a pochai. It's something knows. My understanding of pochai is very limited. I go by the definition of I go by the definition which is under the act. My lord, it's ultimately, if ultimately, my lord, that's why, my lord.
Where is the Pochai definition?
Yes, Excise Act, my lord. Let me see.
Pochai, yes, 4C, 4D.
No, it's
Pochai for consumption of.
My lord, kindly see the act. Act.
Correct, correct.
Pochai means fermented rice, millet, or other grains.
Where?
My lord, from the act. My lord,
Yes, act I am there.
no, page 8. Page 8.
Yes.
Means fermented rice, millets, or other grains, whether mixed with any liquid or not.
Where it is? Pochai, where, which
Obtained,
section?
yes.
Which section?
16, two definitions, 16, your lordship.
Pochai means fermented rice, millet obtained whether mixed or any liquid or not any liquid is diluted. Okay. Then 59, what the 59 says? The number of license may be granted to any local area. Be regulated needs the people of area. No license for the sale of intoxicant required either meet a certain demand. So how the Pochai come?
That's why, my lord, that is the, my lord, when I have when I have inquired, situation was different. After 10, 15 years, my lord,
No, that's correct. Now the temple and school is, but you have shown some procedure. It is
But I
existing.
just want, my lord, there is a specific rule that is in respect of Pochai. Page 195. Kindly see. Pochai,
195.
My lord, of the West Bengal, Pochai and Pochai rules.
West Bengal Pachai.
My lord would see 24, rule 24, which is page 200.
Page at this
page 200, my lord, rule 24.
Yes.
The licensed vendor of Pochai shall sell Pochai from vessels or containers in the serial order in which it is manufactured and not otherwise. 27. The licensed vendor of Pochai shall not sell Pochai which is putrid or otherwise unfit for use or which has undergone fermentation for a period of 12 days or more. But these are the restrictions. And one restriction is there, my lord.
So how the Pochai will come here?
But shifting, there is one restriction.
Now how the Pochai will come here?
Because he is having a license of Pochai only. Pochai? No, his supplementary license is country subject to correction, my lord, that is recorded in the order itself. Subject to correction.
No. There is no license of Pochai. Can you come to the license? Where is the license?
My lord, license is not, kindly see, my lord, the first page 23 itself. Approval of proposal for shifting of Chandai Pochai shop. Pochai shop. It is not a normal Pochai shop from his existing site to the.
Where is the license?
And it is recorded in the recorded in the order. Recorded in the order. Page 27. Kindly see. Affiliate is the holder of the excise license for retail sale of Pochai for consumption of on the site, operating under the name as Chandni Pochai and supplementary country spirit shop. So main license is, my lord, for Pochai only. So question is, my lord, today.
Yes.
And my lord, kindly see just another, my lord, shifting rules, which is at page 99. Shifting rules. The West Bengal excise shifting of existing site or change of premises of excise license.
Yes.
My lord, kindly see the second proviso of 4.3.2, which is at page 100. Second proviso of 4.3.2.
4.3.2.
Page 100, next
Yes.
page. Provided further, such prayer of shifting or change of site in the neighboring excise district shall not be allowed more than once. First, my lord, of the same district. Page 23 would indicate.
Proposal is suitable for the respect if applicable to grant license for other category 4.3. Provided the collector shall consider the case only when the said license has been operating at the existing site for the last 5 years at the stretch, except when the collector is satisfied the shifting or change of site is necessary in the interest of the people residing in the area, or such change of shifting due to the change of existing rules or procedure which is beyond the control of the license. Correct.
Now, the proviso is provided further. So it was beyond the control.
Provided further.
Such prayer for shifting in the neighboring excise district shall not be allowed more than once. So, if again he has been asked to shift to the original, he has been allowed once. So it will be at twice in the same district.
No, but
one was without.
That is not in the normal condition.
Normal condition.
Here this is not the normal condition. Here there is some extraordinary condition.
Well, may I just may summarize my points. I'll take another 1 or 2 minutes. But question today, he was having a pochai shop. Supreme Court comes and interferes and lays down the guideline or the legislature. We all follow that. He shifts to another place, whether he was doing business from that place or not, that issue is no more German because the issue has been compounded. Now, question is, he wants to go back to his original position. He says that original position remains an existing site. This is the only issue.
Correct.
But I say this could not have been an existing site once Honorable Supreme Court put in an additional restriction clause, and that restriction clause remains. It is only some meters or the diameters have been changed, altered. It is the restriction has not been evaporated, subject to correction. The restriction remains 500 to 200. There has been some relaxation. Now,
if suppose, okay, Supreme Court passed an order, shifted. Subsequently, Supreme Court order relaxed. So whether he's not entitled to get for shifting the original place.
I bow down to he is entitled to, but how he would be considered? It is not here. We are not saying
whether that the explanation is to be taken into consideration strictly sensio, or to taken into consideration of the extraordinary circumstances which arose due to the order passed by the Honorable.
Kindly considers also the time gap. Now, this is one of the elements my lord has to because meet the demand of the people. Rule 9 says so. Rule 59 of 85. That meet the demand. So, this is at best a privilege. The Supreme Court in 2017-6 has also clarified that it's a privilege. It's not a fundamental. It's not a. Today we are not enforcing a fundamental right that it can.
No, you are not. If you are telling that you are not entitled to extend the excise license, then he challenge that is different thing. He is not challenging. You have not denied for renewal, extension, or opening of the shop. You are not. Here only the question with regard to whether he can be allowed to run the business in the existing premises which he was before the order of the Supreme Court. If you have not extended, if you have cancelled, and he is challenging, or he has filed an application for renewal of the license or grant of new license, you are not giving, so it is not a fundamental right to challenge that.
Yeah, bow down to
that is the criteria.
But whether
so let us decide.
Only thing, today, as on today, ICDS has come up. I see that, and Anganwadi, and our High Court has held Anganwadi to be an education institution.
No, that's why he has shown rules, because I could not.
No, just paragraph 11. This has.
No, that's correct. That is everywhere. Either school, temple, or hospital?
My lord,
School,
I-
temple,
my
hospital.
lord, I am satisfied. My lord has given me an opportunity of making my submission. I leave it to the difficult
Hey,
part.
I
to
don't think any of the bar member will say, this court is
My
not
lord,
giving.
my lord, absolutely, my lord. Everyone gets opportunity to exhaust themselves. Everyone, my lord, everyone.
Because people are coming to
No, no,
get
with
the
so much
justice.
pressure, my lord, this residuary jurisdiction, my lord, tremendous.
Always a very heavy jurisdiction.
My lord, only kindly considers, my lord, I would again, my lord, reiterate.
What is the restriction in the state of West Bengal with regard to the temple, school, or hospital?
Within 1,000 feet
1,000 feet.
of that temple or that
No,
school.
that is the rule ta dekhiye dao na, my lord.
Rule 8 পড়ে দিচ্ছি।
Rule 8.
This the site cannot be granted. May I place the rule, exact rule, your lordship?
My
On
lord,
the last occasion I had.
Yes, you have shown that.
মানে এখান থেকে বইটা আছে বলে বললাম, এই রুলটা থেকে বলে দাও তাহলে আমার সুবিধা হয়।
My lord, your lordship, on the last occasion.
ऐसा book मंगाया करो बाबा. Book मंगा
It
के रखो.
apply
A restriction for grant of.
restriction on grant of license at certain new sites.
My lord,
Rule 8 at
my-
the top, your lordship.
My
will
lord,
get
before my lord, what are the amendments made? I should have shown it. I'm tender by page 9 of that book. My lord, kindly see what were the amendments after this Supreme
Yes,
Court
ওটা আমি
judgment.
আসতাম।
I'm tender apology, my lord. I should have shown page 9 of the 2003 rules. 383.
Provisions of supplement definition intoxication drugs.
No, my lord, that book,
Your book.
yes, my lord.
Yes.
Page 8 is the restriction on grant of license. Well, this is the rule. It starts after page 60. 60.
Acha, 6. Yes. Page.
But I will try to arrange a book. This is out
You
of
do one
publication.
thing. You do one thing. Let me hear. I will hear.
This 3 rules, 3 is there, because this is the my learned
Which
friend-
page? Which page you are referring?
9.
Page 9.
Yes, my lord, 9 of that rule.
Yes.
My distance restriction
National
from
highway.
national highway, state government shall notify the distance from outer edge, so and so. But this was done after the first judgment,
Yes.
7th April 2017.
Hmm.
And Roman I is such site is situated within 220 meters from the outer edge of any national or state highway or of service lane, so and so. And this was incorporated. The next page, my lord would find substituted by notification dated at 6th August 2018.
Correct. So that is the only this with regard to the state highway.
Say
No, with
highways.
regard to this temple and all these things.
I'm grateful, man.
How much time will it take? Take time.
Bit.
Fixed matter আছে কি?
Yes, my 12 p.m. My lord, I am.
Come tomorrow.
Lordship.
You also come with the short notes. All this so that I can take. I heard the London Council for the respondent has argued the matter at length, but due to and concluded his argument, but due to paucity of time, London Council for the petitioner could not get an opportunity to give reply. Let the matter tomorrow under the same heading.
আমার নোটটা আমার হারিয়ে গেল।
Yes, next.
Well, may I take back the book?
Book to वापस.
May I pray for Milord and undue indulgence from your lordship?
Book दे लो book. अच्छा note करेगा. They will note and it will bring from the library.
Milord, may I? The fixed matter is taken up. May I, Milord, pray for an undue indulgence?
Yes.
Milord, item number 20 was mine. Milord, I am not, Milord, asking for the matter to be taken up. Milord, I am carrying, Milord, an ugly face in this matter. Milord, I applied for extension to put in reply, which is not yet ready. I am told today, Milord, in the morning. Milord, I have requested my learned friend on the other side to come. He has graciously, Milord, consented to, Milord, further extension. If, my Lord, may I have a week's extension to put in
Item
reply?
number?
20, Milord.
20.
20.
Record an order. Item number 20. London Council for the petitioner. Praise for extension of time to file affidavit in reply.
And supplementary affidavit, Milord, that was the order. Affidavit in reply and supplementary
And
affidavit.
supplementary
No, that was
affidavit. Let the same be filed within a week.
Yes, Milord.
Please the matter on 23rd February.
So grateful to your lordship. Extremely grateful. Madam, grateful to my learned friend also.
Yes,
Grateful.
next.
Grateful.
My lord, in this matter,
I need to file my written notes from Argun.
Which matter?
Under item number 5.
5. This was the petitioner.
Losses kindly consider the last order passed by the
But my lord, without giving hearing to the respondent, will not kindly not pass it.
What?
But I am not getting opportunity to.
Yes, are you?
Yes.
The best part, my lord, let
Well, let them finish
let them conclude your losses, then I will just remind you.
Okay, Mr. Sandal, that's a copy.
Yes.
Sir, আপনি বলবেন কি?
No, আপনি বলুন।
My lord, there are
I will respond.
two aspects in the matter. My lord, admitted position, a license was granted to my learned friend on the premise that he was a tenant of the private respondent, and there is no dispute. But there are internal disputes in between. There are suits. They have, my lord, they have taken. There are internal disputes. There are suit. Is also allegation. He is not that the part of the license while he has been granted, he is not running the business. These are the facts. But subsequently, it was found that the land has been acquired by the irrigation department.
Yes.
It was found. My lord, on such premise, the first writ petition, one of the writ petition was filed. My lord, I just try to take what are the observations to that. My lord, today, my lord, the order is you cannot run from a government land. It is court wanted to ask, the honorable single judge wanted to tell whether we are in urgent need of that land or not. But subject to correction, possibly, my lord, no proceedings কি শুরু হয়েছে? Because unauthorized occupant act, he has to his right is court terminus. Tenant's right is court terminus. But I cannot fight crossroads on such issues. But the fact remains, but the land is a government land, has been accepted by the parties. But I wanted to show. But দাদা এরকম ভয় পাই তোমাকে দেখলে এমনি ভয় লাগে আমার ইন্টিমিডেট করে দাও মানে to kindly see the order of page 97 of the writ petition.
You are appearing for the respondent number?
মানে state government.
Yes.
মানে I am appearing for respondent number 2, 3, 4, 5, 6. Yes. The government authority. মানে do fine. Page 97, the order starts. I'll rely upon page 98, paragraph 6 onwards.
98?
Yes.
Yes.
In compliance of the order passed by the court, the superintendent of excise heard the matter and passed an order on so-and-so by observing that the superintendent of excise has no discretion in deciding upon the terms and condition of settlement of the excise license as per the Bengal Excise Act as amended. The superintendent of excise observed that in terms of section 31 of the said act, the collector is the competent authority to grant license at the existing site for the next period of settlement. On reference from the superintendent of excise, the collector took up the issue and heard the parties. On so and so, the collector opined to direct executive engineer, irrigation and waterways department, Tomluk, to inform their stand on the running of FL shop from the land premises owned by the irrigation and waterways department. The licensee, that is the petitioner herein, was directed to submit valid document proof pertaining to the said site for running the license shop. It was recorded a failure to produce any document in support of ownership of the site shall automatically lead to the stoppage of the shop operation. A spot inquiry was conducted in the presence of the block land and land reforms officer, Bashkura, to ascertain the plot number from where the petitioner was carrying on business. It was found during field inquiry that the shop is situated on plot number so and so. The shop occupies the area of so and so in plot so and so and area of so and so in plot number so and so. On September 12, 2024, the matter was posted for further hearing before the collector on October 3, 2024. On the said date, the petitioner made a request to adjourn the hearing on medical grounds. The DM so prayer has been under counsel, has been submitted. Paragraph 15, my lord. Next page, paragraph 15.
Yes.
There is no recording in the order dated October 3rd, 2024 with regard to the immediate urgency in disposing of the matter ex parte. The FL1 shop is running from the said site since the year 2004 as per the license issued by the authority. It does not appear that there is any pressing emergency to dispose of the matter, ignoring the request for adjournment made by the petitioner. Neither the records placed before this court nor the impugned order so and so disclose the date of acquisition of the subject land by the Irrigation Waterways Department. There is nothing to suggest that the requiring body raised any objection against the petitioner for running her business from the acquired plot of land. It has been asserted by the learned advocate representing the petitioner. There are several dwelling house and shops situated over plot number so and so which has been acquired. But But this is the submission of the petitioner. Petitioner means my learned senior friend's client, acquired for the Irrigation and Waterways Department. As the shop in question is running for a considerable period of time, the DM and the collector ought not to have rushed to direct the licensee to stop the operation of the business. The authority ought to have further ascertained as to whether the department has any objection in running the said shop from the plot which was acquired from the Irrigation and Waterways Department. Debarring the petitioner from running the shop within 45 days from the date of the order without granting her reasonable opportunity to place record in support of her status in respect of the said land would result in the closure of her business, which would directly impact her livelihood. The authority ought to have deliberated over the issue as to whether there was any requirement of passing such order for immediate closure of the business if the requiring body did not intend to use the acquired land for their own purpose. As it appears that the right to livelihood of the petition would be directly affected in view of the ex parte order that has been passed, so and so the court is of the opinion that on this premise, the
decide and demand.
but the fact remains, but it's a government land, it is being accepted by the parties, say, interstate parties. Now, my lord would kindly see the order passed, the impugned order, which is at page 106, below level.
Yes.
Hearing in compliance with the Honorable High Court order in so and so. My lord, I'll start from the word the hearing is being held.
Yes.
Fourth paragraph, first, second, third, fourth. Is being held to grant an opportunity to so and so to place documents in support of rightful possession of the rented site where from her excise license shop is running. So and so has submitted written submission informing willingness to shift to another suitable site through letter to us. A detailed application for shifting the license shop from the present site has also been enclosed with the aforesaid letter. An opinion regarding the piece of land so and so was sought from the concerned Irrigation and Waterways Department, where the concerned license shop Srimati is situated. The concerned executive engineer has informed reader letter number so and so that the said piece of land is owned by Irrigation and Waterways Department, though they could not mention the date it acquired. He also informed that the concerned department has not issued any NOC in favor of the concerned Kolaghat FL on shop as per his office record. Further, it is stated that the aforesaid letter of the executive engineer that as the licensee cannot produce any departmental NOC, naturally, an opinion has sought from the office of the Excise Commissioner West Bengal regarding the matter in terms of the Excise Directorate so and so. The Law Cell Excise Directorate has opined that the terms of Section 2 of the Public Premises, which is a central act and has overriding effect over normal tenancy laws governing the rights of a private tenant. The act prescribes the procedure for eviction of unauthorized occupant of such premises referred to and so if the concerned department of the central state wants to remove the occupant. It is also being occupied to sensitize the license that since the business premises is situated undemarcated land, he harbors the risk of quick eviction on every notice. Hard learned advocate representing Chandan who submitted that some other dwelling house etc. are also situated in so and so, but no objection has been raised with regard to her client. Srimati Chandana Maiti, which is arbitrary, she must be allowed to carry on business of a licensed excise shop, which is her only source of living. The learned advocate also submitted for allowing a reasonable period of time to enable her client Chandana Maiti to shift to a new suitable location. Peruse the written so and so verbal submission so and so. Now the latest report we have find my junior tells me that there's a demarcation has been done. Latest report to the my lord, page 10, affirmed on my lord.
Yes, it is there.
Page 10, my lord. Shakti Bagh, who is the private L.
Shakti Bagh, Pakabari, 16 feet into 41 feet.
Perfect. My lord, his name is there. So, my lord, so this forms, my lord, this has now been demarcated.
So he is a private respondent.
Yes, private respondent. Now, my lord,
So what about the Chandana Mehti?
Whatever co-terminus, the rights is co-terminus, he cannot have a better right than the landlord or the owner. Admitted position, they are tenant and landlord relationship. There is no dispute. It is also there is a submission of my learned friend. Also, that's a government land. There is no at least there is no challenge. This process here cannot be a challenge. This is the situation.
How your authority granted license?
But grant a license at that moment, there is a question of mistake of fact or mistake of law. This is a settled law, my lord. I have taken into consideration the tenanted proportion. He has been shown that the house was occupied in 2004, my lord. We are speaking of a situation in 2004. Subsequently, my lord, it has been found that the land is owned by a government. But that inquiry, possibly, that inquiry, whether ought to have been, there's an affidavit to that extent, but I can file it an affidavit by way of an affidavit, but this is an affidavit filed by them showing that he is the tenant of my land. That's why I said, that was the only inquiry, we did not have the resources or the situation or the rules. Shows that ownership, this licenses is more on possession.
Okay. That's all. This is the submission. So as per still he is in occupation of the government land. Yes, sir.
And my instruction is steps are being taken to evict him under the unauthorized occupants.
Have you started issuing the notice under section 4?
That is
issued under section 4.
That is
Demarcation only has been done.
my landed senior friend has better knowledge of it. I do not know.
And the election is knocking at the door again.
And that
yes.
Yes, my lord. My written argument, my lord, page 5, my lord.
Written argument you filed?
Page 5.
Page 5. Where is the written argument?
Fact I have said, my lord.
Written argument.
I'm an advocate for the government already.
Yes.
Number 6,
You are for the respondent number 6. You are for the respondent number
16.
16.
Yes.
Yes. Yes.
On my petition, my lord, the proceeding was initiated.
Huh?
I moved this petition.
Which writ petition?
Original, I moved this petition. Yes. On page 5, kindly see the
Yes.
respondent number 16, Harry, inherited the property of plot number 163 and 164. 364, 3 and 64. Kotian number 247, jail number Sergeant Sir.
आज की report. Yes, file the report today. It's written notes.
Fine. Yes. By virtue of a deed of...
Where is the document 363 is allotted to you?
Yes, ma'am. I have documents, ma'am. All the documents are with me, my lord.
Where is that?
Originally, my lord, my father was...
Have you filed the affidavit?
No,
where is the document?
Madam, direction was not made, nor was given to me to file affidavit. That is why, madam, I could not file the affidavit. Direction was only state.
That's true, your lordship. Report was called for from the state.
Your lordship, I see the order. Whole order, see, my lord. Well, all the documents are with me, my lord. 363 originally, my father was originally owner of the property, my lord. Then, sometime I could not know. I do not know whether the land has been acquired by the irrigation department. When I filed this petition, my lord, I came to know that this land has been acquired by the litigation department. All the documents
Yeah.
are with me, my lord. Deeds
Be-
are with
before
me.
before the authority, district magistrate, you had appeared when the order was passed on 29 January.
Yes, and also contest.
Where is your submission that you are the recorded owner of the property? Kindly come to page 106.
But it page my lord, 106.
106. Where is your presence? Have you present before the authority?
Yes,
Where? Where is your submission?
My junior is reading, my lord.
Number four minus and opinion regarding the piece of land of being dark number 363 Mojak such and such manner was shot from the concerned irrigation and waterways department where the concerned license of Srimati Chandana might is situated. The concerned executive engineer has informed site is
That is where you have submitted. No, this is not correct. This is the 363 is allotted to you. Where is that?
that submission is not recorded.
Your presence is not required recorded there. Where? Show me. See the first paragraph. Yes, Mister. They are present before the authority. They present.
May not record it, but I have.
Why you not filed all the document? What is the document you relied upon?
But I'm told, my lord, I'm not sure.
What are the documents?
That they have filed another suit recently against me for eviction.
That is different.
He was present. My lord, it is recorded in the order.
Where is that?
Kindly see. My lord, second paragraph of page 106. Shakti Bagh, landlord of the license, also remain present. Second paragraph, 106.
Landlord of the license also
Remain present.
Landlord of the licensed.
Yes, my lord. He is the landlord, Shakti Bagh. He was present.
Sometimes I also landlord up to my lord 2015.
Ah.
Then when the agreement not extended.
So you land belongs to whom?
Government land, my lord.
How it has come to the government? You file the report. I am giving because where is the document? You file the supplementary affidavit. I am sending it to you. How this 360? If the 363 is of the private respondent, how it has come to the irrigation department?
Just is enough in the first order. Recorded that. They have to ascertain.
Well, this is the submission of the petitioner. I showed
No.
the order.
Because the private, he is not. He kindly private this.
He has not challenged. Well, he has not challenged.
He is not challenged.
Subject to correction, carriage of proceedings is not. He is not challenging.
But he is the private respondent before this court.
well,
Just a minute. He is the private respondent before this court. Now he is filing some document before the court. The court cannot shut the eye.
My lord, I beseech, my lord, if I have said something like that, I tender unconditional.
No, nothing.
I am saying, my lord, this inquiry can only be gone into at the stage whether he is unauthorized occupant. Any provisions have been invoked under the unauthorized occupants.
Sir, unauthorized occupant is different thing. Unauthorized occupant is a summary procedure. I know. What would be the fate of the unauthorized public premises act? I know very well. Correct. So your authority will say, I am not the authority to decide the title. In the public premises act, you will issue the 41, 43, 412, then 5 and 6.
The record of rights.
State, my lord, cannot produce any record.
Correct.
This was acquired.
No, my lord.
That was absolutely, my lord.
So that's why.
My
But
lord,
where is the document?
My lord, page 10 of my first report, kindly see the record of rights. Subject to correction.
Record of rights is something.
No, that's why how you are acquired. And when if it is acquired also, where you taken the possession?
My lord, I filed an RTI application.
See, there are several things, sir. If the authority is found, he is the owner of the property. or his father was the owner of property. Subsequent, the property has been acquired by the state and have been handed over to the irrigation department. There should be a acquisition proceeding. One thing. Second thing, if the acquisition proceeding is there, then there will be a notification. If there is a notification, there is a compensation. If there is a compensation, there is a possession.
But my lord, I can challenge it.
You are not coming with any document. Where is the document?
These are the documents.
Well, whatever documents.
Why you are not placed before the authority? Why you are not placed before the authority?
Well, authority my lord asked me to, but giving a opportunity hearing, I appeared and I conducted the hearing.
My lord can remand the entire matter to the author because this issues my
That will be the better.
has to.
But I don't know what is the document. It's the Bangla language. I don't know.
He cannot challenge my lord.
You do one thing. I am granting you liberty to file the affidavit in opposition disclosing your defense, whatever the document. If this court satisfied your document has to be considered by the authority, then I will set aside and remand the matter to consider this document.
Ultimate beneficiary, my landed friend.
You have granted.
My lord, he
But
will
only
run
one thing, your lordship.
the business on the government land.
My lord,
But if he says it's a government license, I do not have anything.
I am not on the government
But
land.
I do not need to argue anything more.
I am on the private land.
Honorable court is allowing him
He
to
is
run
saving
the
his
case
skin.
on the government land.
So this order will not affect. So you are not aggrieved with this order. If the order passed by which the order 106, you are not aggrieved with that.
No, that will
Lord,
not
I
be
tell you,
affected by that part.
You are not aggrieved with that order.
No, that is not given by the order. But my lord,
If I am living, my lord, if my shop is closed, he is not affected. That's the my lord collusion. Once, of course, so long you have not done anything at all, if at all.
Government of West Bengal, I can challenge it. Proceeding or I did not pay any, did not get any compensation, but he have no right.
I have a right as a tenant to
But
carry.
sir,
But he is not a tenant.
one. If he is a tenant or is a legal occupier, whatever it may be, you tell me whether the whole 363 you are the owner or not. You are the owner. You admit that he is in your occupation or not. He is in your occupation or not. Your civil suit, I will decide it herein now.
He was sometime, my lord, he was tenant.
I am only putting one question whether the liquor shop is in your premises belong of the petitioner is your property or not. Tell me. I will decide your civil suit here, then I will record the civil that is to be dismissed.
Well, originally, I was the owner of the property.
Originally, I am not
But
telling.
how it has been acquired by the government?
Acquired by government.
It's a government land.
What submissions he is making, my lord, I fail to understand.
Let
But
him
I
file an
want to
affidavit.
know the
Let him file. Only
acquired
one
by
thing I draw
government.
your lordship's attention. State also should
But
come forward.
But
But
court
kindly have a
cannot
look at page
allow the
103.
petitioner to run the business of
After the Justice
government land.
Sinha's order, Justice Sinha doubted everything. I applied under the Right to Information Act. And they
The
said,
petitioner has challenged the order passed by the additional district magistrate and collector Purba Medinipur, dated 29th of January 2025. During the pendency of the present writ application, this court has called for the report from the authority, and the respondent number 3, 14 and 15 have filed the report, wherein it reveals that the private respondent number 16 is in illegal occupation of 16 feet into 41 feet equal to 656 square feet, wherein the petitioner's shop is situated. Licensed shop is situated. The private respondent submits that he is the owner of the property in question. It is fine from the impugning order that the private respondent was present, but what was his contention before the authority was not appearing in the impugning order. Accordingly, this court is of the view that that detailed affidavit is required to be filed by the authorities as well as the private respondent. Let affidavit in opposition be filed by the respondents within a period of 3 weeks. Reply, if any, there to be filed within 2 weeks thereafter. List the matter on 25th of March 2026. The interim order is extended till 27th of March
Not
2026.
only one more request to your office to settle the entire issue. Matlab, kindly direct the state to produce its records of acquisition.
Let the affidavit come. Let the affidavit come.
I'm grateful, man.
उसको वापस कर लो.
Matlab, would you also make it hard in part?
No. Affidavit is not. Yes, next. Yes. What is the prayer? Unauthorized construction made by the restaurant number 7 by encroaching the land of the restaurant number 1, 2, 3. 1, 2, 3 and 5 and 6. Who are you?
Well, the unauthorized construction of the public under the Highway Act. My lord.
Who are you?
Well, I am the adjacent plot owner. My lord, my ingress and egress was blocked. My lord, we previously moved the writ application with this honorable court. At page, my lord, 50, my lord, you will
page 50.
50.
Yes.
Well,
what is there?
The honorable court directed the my lord, to consider, directed the assistant engineer, my lord, the respondent number 9.
Dispose of the direct and respondent number 9 to consider and dispose of the representation submitted by the petitioner within 3 months. Yes. Then
after we communicated the order to the respondents, my lord, they did not take any steps. My lord, the communication as page 52, 53. My lord,
then what has happened? Nothing.
Nothing.
So why you not filed the contempt application?
Well, the time was 1 year time was.
So you are also sleeping with the order.
Well, to kindly call for a report. Well,
what report? When there is an order of the court,
my lord,
you are appearing for
the statement.
Well, let them initiate a proceeding. I still
Lord,
need that
their
number
civil
5 and
suits are
6
pending.
who was the ninth respondent in the writ petition? Earlier writ petition, who was the ninth respondent?
Now here is the respondent number 6.
Assistant engineer public works. You are appearing for the assistant engineer.
So all the state respondents. All the state respondents, my lord.
It's no, all assistant engineer also coming under the state. No. So why you not taking?
My lord, kindly consider, my lord, the civil suit is pending on that score.
So pass an order.
My lord.
No civil.
So I am directing to comply with the order to within 4 weeks. And communicate the same, giving an opportunity and
of hearing
communicate the same.
what within a certain
They
time.
admitted in the civil suit.
That's why I am directing to pass appropriate order, compliance of the order dated, giving an opportunity and to communicate the reason and speaking order within a period of
Direct them to take steps as per the Highway Act, my lord.
giving an opportunity. Let what you giving, if they find that you are the private respondents are in occupation, they have to take steps. If they find that,
let first decide what is their
In the civil suit, my lord, they have encroached my lands. File a civil suit.
Who has encroached?
But they tried to the respondent number 7 and 8. My lord, we filed a civil suit. In the written statement, they have categorically admitted they have constructed the house and shop.
Okay, I am giving opportunity. If you file file all the document before the authority. The petitioner has filed the present application praying for a direction upon the respondent authorities for taking appropriate steps against the respondent number 7 and 8 for demolition of the unauthorized construction over the property in question. The petitioner has the counsel for the petitioner submit that on the earlier occasion the petitioner has filed the writ application being WPA 25826 of 2022 within bracket Khadija Begum versus State of West Bengal and others. Here also same. And others. The said writ petition was disposed of by the coordinate bench of this court dated 24th of August 2023 by passing the following order. 51 এটা করি না full stop. The counsel for the petition submitted that the order passed by the coordinate bench was duly communicated to the respondents, but the respondents have not taken any steps. According, the petitioner has filed the present application. Correct? Full stop. Consider the submission made by the counsel for the parties. This court find that once already the coordinate bench has already passed the order on 24th of August 2023, but the authorities have not taken any steps. Accordingly, the writ petition is disposed of, directing the respondent authority to consider to comply with the order passed by this court in WPA 25826 of 2022, dated 24th of August 2022, by giving an opportunity of hearing to the petitioner as well as private respondent, and to pass a reasoned and speaking order within a period of within a period of 8 weeks from the date of communication of the order. Yes.
But if it is found, my lord, they have
Police, it is made clear that if the authority found that the private respondents are in illegal occupation of the property in question, the authorities shall take appropriate steps in accordance with law.
West Bengal Highway Act.
Accordance with law, the court cannot.
Everything will wriggle out.
But by directly the respondent number 6, the 5 and 6.
Authority.
Authorities have been directed.
Yes, next.
No, I am for the private respondent.
Yes.
The petitioner lordship. What happened is, the petitioner purchased a vehicle through an auction purchase, from the bank, Now, suddenly, at the time of getting the registration of the vehicles in the name of the petitioner, the name was not registered. Ultimately, petitioner found, there is a civil suit is pending between the bank and the the erstwhile owner of the vehicle, private respondent.
For recovery.
Because they says, the vehicle has been taken without giving me any opportunity and all, I am not the party in that proceedings. Only things,
Who filed the civil suit?
The private respondent.
Private respondent filed the civil suit against the bank.
Against the bank.
For
Now,
what is the prayer in the civil suit?
My lord, civil suit, my lord, perhaps, my lord, there is one thing, my lord. We have given a substantial payment in that payment.
What is the prayer in the civil suit?
Civil suit, my lord. My lord, in the civil suit, my lord, for declaration, the plaintiff is the lawful owner of the
Against whom you filed? Against
bank.
whom you have filed?
The bank.
Bank. Yes, declaring you are the owner of the property.
My lord.
Declaratory suit. Declaratory suit. Yes. Then what has happened?
An order of injunction was passed.
What is the nature of injunction?
My lord, the vehicle cannot be the vehicle cannot be given to the third party. Third party right cannot be.
Third party that cannot be created.
Page 38, I have annexed that, interim order,
38.
Lordship. The interim relief as prayed for by the plaintiff is hereby allowed, restraining the principal defendant from selling the 12-wheeler truck bearing number so-and-so with registration number so-and-so till 39/2022. But according to my information, my lord, this is still subsisting. My lord.
Subsisting, my lord, and it's going on, my lord.
What is the stage of the suit?
The stage of the suit, my lord, bank has entered appearance in the suit. As for my last information, my lord.
Entered appearance?
No steps has been taken, my lord, to vacate the interim order.
Because, my lord, I must, my lord.
What you are praying? What you are praying?
Now, my lord, I am praying, my lord, I have paid 15 lakhs and odd to the bank in 2022, my lord. In the auction purchase, but I am the successful purchaser.
Vehicle is with you.
Yes, my lord.
So
4 years, the 4 years I couldn't use the vehicle. It is lying in the parking because the vehicle has the transfer could not be made because of this interim order.
So is the private vehicle?
It's a private
vehicle.
vehicle.
My lord. Even, my lord, private respondent has paid a substantial amount for that vehicle, my lord. Defying all, my lord, they have
how much amount you have taken loan from the bank?
Bank, my lord.
And how much amount you have paid?
9,60,000 by last time we have paid.
What is the amount, sanction amount?
Sanctioned amount.
Who is appearing for the bank? Yes. What will happen to the vehicle?
That the vehicle, there was an arbitration clause in the agreement. Due to default, arbitration proceeding was initiated. Award was passed in 2021. Pursuant to that award, the vehicle was taken possession and sold.
Who has taken the possession of the vehicle?
The bank pursuant to the
You have
award.
purchased from the bank?
Yes, my lord.
Okay.
Now, after sale of this vehicle in favor of the petitioner, my lord, this suit has been filed and this.
So how the civil suit is maintainable?
My lord, one thing, my lord.
May I just submit, my lord? Now, how this interim order, first of all, my lord, this interim order is subsequent to the sale of the vehicle, my lord. Now, how this interim order is creating a trouble for the transferring authorities, my lord, to get the vehicle transferred in the name of the petitioner, if I ask myself, my lord, because that suit is filed by the private respondent against the bank. The registration, the authorities are not party to the suit, my lord.
Which authority?
The
Registering authority.
Registering authority, my lord. There is no order of injunction restraining registering authority from transferring the name of the vehicle in favor of the purchaser, my lord. There was an interim order.
Why you are appearing in the suit?
That I have to take instruction.
My lord, my lord.
I have information on 10th of September 2025. Bank has taken time.
This is the schedule of payment, my lord, that I have made, my lord. 14,45,000, my lord.
But whatever it is, there is an award.
There is an award.
So you are not challenging the award.
Yes, my lord.
So how if there is an award under the Arbitration Act, so how the civil suit is maintainable? Can you challenge the award under
one
the?
thing, my lord. One thing, my lord. One thing, that this entire episode has taken place during the COVID period.
Maybe
I was not duly as in.
So you could have been filed at 34.
Lordship.
And you cannot now the 34 you cannot.
No.
You not file the I am deciding herein now.
My lord, kindly bear this in mind that I have paid a
How the
substantial
civil
amount, my lord.
civil court is proceeding with the matter?
Lordship. I have paid a substantial.
Maybe, but see, arbitration proceeding, you got the chance. Whatever this court cannot sit over not the arbitration court, and you are not challenged this award passed by the arbitrator. So,
and I have also annexed the award also.
Can this court sitting in the writ can go into the matter merit, or the civil suit can go into the merit?
My lord, one thing, my lord, the civil suit is pending over there, my lord. The injunction, order of injunction is still subsisting, my lord.
Maybe.
My lord.
This court will clarify that.
Lordship.
This court will clarify that.
May I make two more submissions, my lord? The petitioner is relying upon page number 36. That's obtained from the Parivahan.
Yes, kindly see, my lord.
Yes, sir, may I just complete?
Yes.
Now, my lord, if I ask a question to myself, on what basis the registering authority has restrained from...
There is an order of the court.
Yes.
That order is not, first of all, your lord...
Not necessary, but the court is... There is an order, they might have been communicated.
No, the order is against the bank not to sell and transfer, which is subsequent to the sale of the vehicle, my lord.
My lord.
May I just complete my
My lord, one thing, my lord.
May I
Despite this.
Let me complete.
Yes.
And even if there is a violation on the part of the bank, the bank would be liable under contempt, my lord. But the registering authority in no manner has been directed to restrain itself from transferring the name in the favor of the purchaser, my lord. All this has happened subsequent to sale of the vehicle. Moreover, the petitioner herein, instead of taking any step against the registering authority who has refused to transfer, now in the writ petition has seeking recovery of money. Kindly come to the prayers, my lord. Direction upon the private bank to refund the money taken for the sale of the vehicle. The prayers can be made before a civil court if at all the petitioner.
Now, my lord, I am not the party to the proceedings. And why they have...
Who was the claimant before the arbitrator? Bank.
Yes.
Correct. And by an interim order, the arbitrator has passed an order to take possession.
Yes, my lord.
Kindly come to the page 20.
Yes.
In the light of the above, in the interest of justice and for the protection of the claimant interest in respect of the so and so, the claimant to repossess the vehicle. So you are the claimant before that. So whether you repossess the vehicle.
Yes.
Okay. Then what is the award?
Starting from page 21.
When the final award was passed?
In 2021. It's
27/11/21, page 29, my lord.
27/11/2021. What is the award?
The last portion in
14
compliance
lakh, the
thereof.
sum of rupees 14 lakh 35,309. Interest 18 lakh, the arbitrator itna the non-compliant. So, in the result, they allowed respondent is directed to pay sum of rupees so in compliance of the open so in So what is the total amount paid by you?
I am paid below 15 lakhs, 15 lakhs 5,000 as auction in the from the auction.
When you purchase the vehicle?
Vehicle purchase in 2022, 18/8/2022.
So what you have done with regard to the remaining amount?
And I have paid 14 lakhs.
Is what you have done because the award is 14 lakh 35,000. So you are
There is also a cost of the proceeding and together with interest, my lord.
Ah.
How the adjustment has been made, I can come back with that calculation.
yes. What about your suit?
My lord, suit is pending, my lord. My lord, one thing, my lord. Despite the passage of that award, my lord, I have been asked to pay the money to the bank, and I have paid that money, my lord.
When?
Beyond the
After the passing of the award, my lord.
When you pay?
My lord, the payment schedule is my in my plaint, my lord. I have paid. My lord, the bank has taken money from me, created third party right to the petitioner, my lord.
And from 2022, we are the worst sufferer.
Both are sufferer, my lord.
But this when you paid?
My lord, kindly, my lord, there is schedule of payment, my lord.
Schedule of payment. Schedule of payment. How you have paid?
My lord, we have deposited the money.
You bring that. You give this schedule. You bring the total details here.
Yes.
How much amount you received from the claimant after the award?
After the award.
After the since because what the tribunal has done.
Tribunal, my lord, said, my lord.
No amount has been paid.
You're not placed all. You're not placed the said document before the tribunal.
My lord, I didn't get an opportunity to appear before the tribunal, my
So
lord.
you're not challenged that.
My lord, I bow down, my lord. I have not challenged that, my lord, because, my lord, due to that, my lord, the arbitration has taken place. My lord, the arbitration has taken place far away. It's not in West Bengal, my lord. And at that point of time, I didn't have the opportunity to appear before the tribunal, my lord.
All these things could have been said in section 34, my lord.
Madam, when the award was passed?
In 2021.
Date?
27/11/2021.
27/11. You have received the amount from the owner 30/11, 18/12.
That is their contention, my lord.
That's why I am directing whether you have received this
Yes,
payment
my
or
lord, I
not.
will come back.
The petitioner has filed the present application praying for a direction upon the respondents to refund the purchase amount of rupees 15 lakh 5,000, which the petitioner which 15 lakh 5,000, which the petitioner has paid to the respondent bank,
Lordship.
to the
Through auction purchase, my lord.
to the respondent bank through auction purchase with respect of the vehicle bearing registration number WB67 capital B 1212, comma chassis number MAT 466 388 capital F 3 capital J 20525, along with interest at the rate of 12% per annum, and the loss incurred therein. Police. Counsel for the petition submit that the bank has auctioned the said vehicle and the petitioner has participated in the auction process and has purchased the said vehicle for the total amount of which is 15 lakh 5,000. Police. Even after purchase of this, though the bank has handed over the vehicle to the petitioner and thereafter the petitioner has applied for transfer of the ownership, comma, the registering authority have refused to transfer the said ownership of the said vehicle on the ground that that there is an order of injunction passed by the civil court, dated 30th August 2022 in TS number 341 of 2022. Full stop. The private respondent, who was the actual owner of the property vehicle in question, submits that he has filed the suit praying for a declaration that the vehicle in question, the private respondent is the owner of the property, and the defendant and the bank has illegally and forcefully taken the said vehicle from the possession of the petitioner. This court finds that the bank had initiated an arbitration proceeding against the private respondents. Both are the party here, both private respondents.
Yes,
Both private and small parties.
Against the private respondents, and by an order dated 8th of September 2021, the Leonard sole arbitrator passed an interim order, giving permitting the bank to repossess the vehicle whenever it is found in a lawful manner with the police protection if required, and to keep the vehicle in their custody until further order. Subsequently, the arbitrator has passed an award on 27th of November 2021 by passing the following order, page 28 and 29. Now the counsel appearing for the private respondents has handed over the copy of the complaint and submit that since the year 2019 till 5th of July 2022, the private respondent has paid an amount of rupees 14,45,735.67. The details appearing in the said plaint, it found that the private respondent alleged to have paid the amount to the bank even after the award passed by the arbitrator. Full stop. The bank is denying the said receipt of the said amount. In view of the above, this court is of the view bank has to file the report whether the bank has received any amount from the private respondents after the award passed by the Leonard sole arbitrator dated 27/11/2021. Let the report be filed by way of an affidavit after serving the copy to the Leonard counsel for the petitioner as well as to the private respondent within 2 weeks. List the matter on 5th of March 2026.
Kindly record two more submissions, my lord. First of all, neither of the respondents are stayed within Article 12. All the bank is a private bank, my lord, and there are private respondents. And the relief sought for in the writ petition is in the nature of a recovery. Kindly
come when the report I will see to that.
I'm challenging the maintainability.
I appreciate your maintainability. I will report.
After hearing, after passing the order, my lord.
I appreciate. I will appreciate.
But it appears from the conduct.
I will appreciate your maintainability. Let your report come.
Yes, my lord.
Yes, I will see.
Petition I have stated that.
My lord, yes. Can I have a copy of the plaint का copy दे दो.
Grateful.
May I be served with copy of the plaint so that I can.
My lord, they are already
Here the plot.
That appearance, they are taking no steps, my lord. They are sitting idle.
Give the copy. The private respondent is directed to serve the copy of the plaint wherein the private respondent has given the description for making the payment to the bank even after the award passed by the sole arbitrator. The private respondent and the bank has raised the question of maintainability. The side is kept open.
Lordship.
Yeah, call the next matter.
Lordship, item number 16 and 17, Lordship, I am appearing. Lordship, item number 16, I am on behalf of the applicant, Lordship.
Time for the petition.
With your permission, Lordship, kindly allow me to submit, Lordship.
15. Item number? 16 and 17.
16 and 17, Lordship. With your permission, Lordship, kindly allow me, Lordship, at first for securing the judicial time, Lordship. I am the applicant. I am the applicant, Lordship, CAN number 3 of 2026, Lordship.
That is not the
that
Can please not before this court.
Yes, Lordship. Item number 16, Lordship.
my lord was hearing the main writ
Can
petition.
number?
3, Lordship. Can number 3, Lordship.
Not even served upon me, my lord. I am the
Can
petitioner.
number?
No, I have served, Lordship. I have served, Lordship.
That is not with this court. Can number 3 is not with this
Your
court.
lordship is
Yes,
hearing the
Lordship,
main
it is on record, Lordship. In everyday, Lordship, it has reflected in the order copy also. I am
That
appearing.
is not in
but
the
may I just lord your
Lordship,
petitioner's case
16 and 17 is that, Lordship, kindly allow me, Lordship, please. I am the affected party, Lordship. Item number 16 and 17.
Yes, let
Item
me
number
hear
16 and
the, let
17.
me hear the matter on merit. I will see to that.
Lord, I appear for the Pharmacy Council. The case of the petitioner is that once a nomination is made as a member of the council, that nomination should last for a period of 5 years. He has made his submission on that. Lord, if your lordships kindly take the writ petition, come to paragraph 4.
Yes.
You are appearing for?
I am appearing for the Pharmacy Council.
I appear for state. Who has nominated him? State government action which I am challenging.
May I just, Lord, indicate I am not going to, Lord,
I can finish, my lord, maximum 7 or 8 minutes.
তুমি কি আগে বলতে চাও?
I can finish.
Lordship, there is a written order of the coordinate bench, Lordship.
I don't
There
mind.
is a written order of the coordinate bench, Lordship, to heard my matter together, Lordship.
Okay, 6 minutes. I am giving the 6 minutes to you.
Fine.
Lord, just hear me.
Applicants are irrelevant, my lord, applications.
Yes, so you are for the state authorities.
It's not been added as part.
Yes.
No, my lord, my lord, the issue is that the nominated members, how long, my lord, he can continue when the council's term already expired. There is no council, suppose. But the nominated member says that yes, even after expiry, now I am the nominated member. Now, lordship, kindly come to my lord. My lord, my matter is very clear, my lord. If we read 2 or 3 sections of the Pharmacy Act, my lord, conjoint reading. Now, my lord, kindly come to section that, my lord, the 19, that is, I think, formation of council.
Yes, constitution and composition.
Yes. Now, lordship, at page 26, and
Yes.
here.
Yes.
Now, 19 speaks that except where a joint state council is constituted in accordance with an agreement made under section 20, the state government shall constitute a state council consisting of the following members. Then 6 members elected from amongst themselves by registered pharmacists, 5 members of whom at least there shall be person possessing prescribed degree nominated by the state government. So far election is concerned, right now in this petition, no problem, no question. So far this petition, only thing, my lord, one of the nominated member, he says that my period has not yet been expired.
Correct.
Maybe that going to expire today or tomorrow, maybe.
Correct.
But when the matter was filed, according to him, not expired. So formation of council by replacing him, another member, that is bad. Now, so whole thing is formation of council, the expression. Now, my lord, kindly come to, my lord, the section 25. Section 23, lordship, kindly come. 26.
Yes.
The president and vice president of the state council be elected by the members from amongst themselves. May I pause here for a moment? The president and vice president of the state council shall be elected by the members from among themselves. My lord, my humble submission, lordship, members mean that members of the reconstituted council.
So, president and vice president of the state council be elected by the members of Members from
From
amongst,
amongst themselves.
Yes.
So members means that the members, that means elected members and fresh nominated members, after, my lord, the council having been formed, 5 and 6, and then, my lord, the president and vice president of the state council be elected by the members from amongst themselves. Well, my humble submission is that this expression member means the member of the newly constituted council, not the elected, not the member nominated in earlier council, who said that my term has not yet expired because of the date of the formation of council. I am coming to that letter within 2 minutes.
New members means the new members.
The members of the newly constituted,
Okay, okay.
elected and nominated. First formation of council, elected, nominated, then they will, my lord, elect or select their president.
Yes.
But this fellow who said that I was a nominated member in earlier council and the date of formation of the council having not been expired, but the fresh council, so I am here, I am nominated, the person replaced me, he cannot be. So my first thing is that the member means that the members of the newly constituted.
So what would happen if the tenure has not been completed? Then
his tenure already completed. I am coming to. I am coming to. Lordship, kindly, my lord, come to. Yes, my lord. The I think the 25, very good 25, heavily relies upon them by 25.
Yes,
Subject to the provisions of this section, a nominated or elected member other than nominated president shall hold office for a term of 5 years from the date of nomination or election or until his successor has been duly nominated or elected, whichever is longer according to them. Now, lordship, kindly, my lord, the fact is that when he was first, my lord, page 41, my lord, no need to, my lord, there is just I am drawing the lordship, my lord, the facts. First nomination was, my lord, made in his favor, lordship, kindly take note, 5th of October 2012.
Of the petitioner?
Yes. In the 2012, when the council was formed, first nomination, my lord, in his favor. He was nominated.
Can you say the date?
5th October 2012.
5th October 12.
Yes.
Correct.
Page 41 is the, my lord, the formation of council notification.
Yes.
Then, lordship, kindly, next, my lord, kindly come to page 43.
Yes.
After that, my lord, the next formation of council, 43.
Second.
My lord, next formation of council, very interesting, lordship, kindly, the page 43. My lord, the notification of dated 22nd of February 2021, right hand side top.
Yes.
Now the language is very important. Language is on expiry of the term of West Bengal State Pharmacy Council on 18 June 2018.
Correct.
2012 to 2018. It is mentioned herein that on expiry of term on 18 June 2018, Governor is pleased to reconstitute the council in pursuance of Act 19 BC-DED of Pharmacy Act. According to him, again he was, kindly see, he was nominated there in serial number 2.
Yes, the
serial number 2.
So it's the 22nd February 2020, 2021, 5 years, it will come to the 2020.
I'm coming to it. It is his case. It is not, our submission is otherwise. So first nomination 2012, up to 2018, what should have been, had it been the council formed at that point of time, council was not formed. But, my lord, whatever the functioning of the council going on, everything going on, he was a nominated member. He acted on the basis of the nominated member. Now in 2021, on the basis of this term of West Bengal Council on 18 June 2018, having been expired or upon expiry, then he was nominated. My humble submission, this is post facto nomination from the date of expiry of the first nomination. So far nomination is concerned, this is not the elected members' election. This is my choice, nomination. I thought that, yes, you still be there. Though expiry of council. Now the council formed. It is, my lord, kindly consider 2021, but upon expiry of 2018.
Correct.
You were there.
Correct.
Still you are there.
Correct.
So this nomination of 2021, these 5 years should have been, my lord, be counted from the date. Yes.
18.
Yes.
Because the 18 to 2021, there was no council. There is no nomination or no election, whatever
Yes.
it may be.
Because
So it was taken only in the 21.
Yes.
So whatever they are continuing, so it is to be taken into consideration extension of 2018.
My lord. Get
2018.
Yes. Because this language is very, lordship, that the after the expiry of term of State Pharmacy Council on 18 June 2018, there cannot be any vacuum on that. He continued there. Then lordship kindly come to paragraph 4, lordship kindly come. Paragraph 4 of the writ petition at page 4.
Yes.
Then lordship kindly come to paragraph 4, almost middle portion. The sentence starts subsequently.
Yes.
Subsequently, on 18 June 2018, he had again been nominated, which was followed by the order dated 22nd February 2021, nominating the petitioner amongst others upon reconstitution of the council upon expiry of the term. Next sentence cannot be read, but because this should be stopped here, that admittedly on 18 June 2018, he had again been nominated. This is admission. That means that when 2021, the notification issued, his, my lord, case was, my lord, post facto nomination. From that date continuation, he admitted it.
So it is a contradictory statement.
Yes. So lordship kindly consider one thing. Now, from 2018, if we, my lord, consider the 5 years, then it would have been, my lord,
23.
ended.
23.
Yes. Now today we are in 2026 January and the matter filed sometimes in 2025. Then the, my lord, excess enjoyment of extra period. Still he is eyeing to that. And stalling everything for one nominated person.
Yes.
What right he has, lordship, kindly consider.
So what
There
about
cannot be any such right.
So what about the 2023 till date?
My lord,
No election.
No election.
Election could not be held. Now election.
then, my lord, I think, my lord, the writ petition filed or other things, many proceedings initiated, and then eventually the election held. And unless and until the election is held, my lord, or the elections are held, the nomination, fresh nomination.
And the election was held.
So election held, and then this pharmacy council again. Now, lordship, kindly consider
24.
24.
Results were published.
Now, lordship, kindly consider, my lord, page number 53. This is, my lord, the last, my lord, the page that I, my lord, want to draw your lordship's attention, page number 53. I think, my lord, this is challenge before your lordship. Page number 53.
Yes.
Again, formation of council, 53, notification. Then, my lord, it carries the date 28th of July 2025.
Yes.
Then again, the language is same. On expiry of the term of West Bengal State Pharmacy Council, the governor is pleased to reconstitute the council. So, upon expiry of term, the term expired. So, everything gone. But the nominated member, so long, my lord, it is my choice. All right, you continued. And it is in paragraph 4 admitted that I continued.
So 2020.
So First 5 years, then second 5 years, he enjoyed. Now, Lordship, kindly come to once more, Lordship. That is, my Lord, the 20. Yes, 25 once more, my Lord. Section 25 at page number 29.
Yes.
My Lord, though the caption is term of office and casual vacancy. Then, subject to the provisions of this section, a nominated or elected member other than nominated president shall hold office for a term. If there's no office,
so they
shall hold office for a term.
Okay.
The council ended, office ended,
Yes.
your term also ended. But still, since you were a nominated member, we also allowed you, as you admitted in paragraph number 4. So, my humble submission, my Lord, whatever my Lord, the grievances he has raised herein, there was no grievance.
Yes.
And the prayer should not be allowed.
So, and what are the 54?
And my Lord, the
page 54?
Page 54, Lordship.
The elected member. They are the elected. They are the elected member.
Elected.
6 persons have been elected.
Yes.
So how the election was held?
My Lord, the election was held, my Lord,
Result
after
was
the
declared on 4th of February 2025.
After the election.
After the election, they were
They have been elected.
the same.
Thank you. May I just add?
Yes. Continue.
Please come to page 43. Paragraph 4 is his admitted case. Your Lordship has seen that. Lord, please come to page 43.
Yes.
My learned friend has placed, Lord, the first paragraph, which says that on expiry of the term on 18 June 2018, the governor is in pursuance of Act 19B C DDE of Pharmacy Act, the following nomination is being made.
You are appearing for the council.
I am appearing for the council. Now, Lord, I request your Lordship to kindly come to the last paragraph of this letter. This council was formed for a purpose. The council comprising above members will take necessary steps to elect members mentioned in subsection A of section 19 of the West Bengal Pharmacy Act,
Yes.
1948.
Yes.
So, my Lord, the purpose of this tenure being given to them was for the purpose of electing members in terms of section 19A. Would your Lordship kindly have a look at section 19A of the Pharmacy Act?
Yes, 6 members elected from the among themselves.
Yes. And Lord, their appointment is in terms of 19B. Your Lordships will kindly see.
4 shall be person
3 persons possessing prescribed degree of diploma, except nominated by the state government. C, 1 member elected from amongst themselves by members of the each medical council, Council of Medical Registration State. DD, officer in charge of drugs control, organized by the state. This is ex officio. And E, government analyst under Drugs and Cosmetics Act. Now, Lord, when this election was held, then, Lord, these 2 documents came into being. Kindly, Lord, come to page 53 and 54. Lord, your Lordships have seen that.
Yes.
53 is the
19B
nominated members and 54, Lord, are the elected members.
Yes.
Both have been announced on the same day.
Yes.
Now, Lord, the point is that the Pharmacy Act envisages a formation of a council every 5 years. And it also says, if your Lordships, if I may trouble your Lordship once again with section 25.
Yes, term of office.
Or rather, Lord, section 24 first and then 25. Elections under this chapter shall be conducted in the prescribed manner, and when any dispute arises regarding them, it shall be referred to the state government.
Where from you are reading?
Lord, section 24 of the Pharmacy Act.
Mode of election, yes.
then subject to the provisions of this section, a nominated or elected member other than a nominated president shall hold office for a term of 5 years from the date of his nomination or election.
Yes.
Or until his successor has been duly nominated or elected, whichever is longer. Now, my lord, once the successor is nominated, lord,
he continue.
The successor will come. The nominee, earlier nominee, will have to vacate the office.
Correct.
And lord, this is the tenure is coterminous. This is the reason why this expression is used, that until his successor has been duly nominated. Lord, a nominee does not have any legal right to continue. The tenure is 5 years. That's the maximum tenure.
But unless the successor has not come, so he will continue.
In the meantime, the successor is nominated. So, my lord, once the successor is nominated, lord, he can't, lord, claim any independent right to continue.
So as per this, as per paragraph page 43, page 43, the 18.6, he was there. So 23 term over, but he continued, and now the page 53,
his successor has
come. So on 28 July onwards, he gone.
Yes,
He out.
He should be out. And once he's
Once he is out, so he cannot claim that he
cannot.
can continue that
Absolutely.
26.
That's my humble.
So what the parade is asking, that is 2026, that cannot be 2026. It is the 5 as per the 2018, 23, but is continue unless the
But I take my argument against me. He is appointed in 21. There was a void between 18 and 21 when he continued. But in 21, when he was appointed, he says that from 21 I get 5 years. I say that 5 years is the maximum period of the tenure of the council. But if supposing there is an election, your tenure will become coterminous with the next committee which is being constituted.
new nominated person or elected person?
Both nominated and elected.
Elected person.
And Lord, here, Lord, it's not that government has just removed him out of the nomination. Government, Lord, has directed them to hold an election. That election was held. There were litigations up to the division bench. And then, Lord, it was referred to a...
How the election was held?
Election, Lord, the results were published on 4th of February 2025. I'll not...
As per election rules.
4th of February 2025, the election results were declared. And Lord, post that, this...
Whether the petitioner participated?
No. He is a nominated member. He can't, Lord, only, Lord, the pharmacists who have a license, they can only, Lord, contest for the election. Otherwise, Lord, the rest are all by choice of the government or the governor. They're all by choice.
Yes.
Some are ex officio and some, Lord, are nominated by the government.
Yes.
These are my submissions, Lord. This is absolutely, Lord, a case where, Lord, he is trying to extend his tenure. There's no harm. Everybody can ask for a little extra. But this is...
Okay, thank you. Yes.
My lord, I appear for the one of the elected members. My lord, I have made my application can 1, wherein, my lord, I have stated that, my lord, there has been an interim order obtained by the petitioner, my lord, wherein the entire work of the council, my lord, has been stalled. My lord, there had been 2 reconstitution.
What is the can 1?
My lord, can 1, my lord, is my application, my lord, for, my lord, modifying the order, interim order obtained, because the interim order, my lord, stalled the functions of the, my lord, council, on the pretext that, my lord, his nomination has been cancelled or a new committee has been formed before the gap of 5 years. My lord, I say that I am an elected member. I am not a nominated member. My lord, as per section 19, my lord, of the, my lord, act, there are 6, my lord.
What is the interim order?
My lord, interim order, your lordship will seize.
Give any effect or further effect to the reconstitution of 29th August.
Yes. So, my lord, this is the reconstitution order wherein, my lord, the nominated members as well as the elected members.
Where is the 29th August?
29th August is the order which he has challenged, my lord.
Where is the 29th August order?
My lord, he has annexed it in the writ petition, page 54, my lord.
That is July, 28 July. So it is wrongly recorded August. It should be July.
Yes, my lord. Yes. My lord, now my contention before your lordship is this. My lord, in my application, my lord, he has filed an opposition wherein at paragraph 7, 9, 11, 14 and 25 of the opposition to Can 1 kindly sees, he categorically says that there has been no stay on the reconstitution of the newly elected members. The only stay constitutes to the nominated members because he himself claims himself to be one of the nominated members. So, my lord, the read petitioner says that there has been no stay on the elected members. 6 elected members have been newly, my lord, elected. My lord, by an order, the order he has annexed, my lord, at page 53.
53 is the nominated and
Yes,
54 is the
54,
elected.
54, your lordship.
54 is the
I am serial number 5 in
correct.
54.
Rameshwar Haldar.
Yes, Rameshwar Haldar. So I say, my lord, the nomination, the reconstitution of the elected members, my lord, should be allowed, my lord, to form the board. Along with the, because there are...
Let the writ petition itself dispose.
Yes, my lord, that is. And my lord, there has been, my lord, there has been the functions, my lord, of the council. All the functions of the council has been stalled. My lord, because no committee could be formed. And until and unless...
Disposing of the writ petition
Yes, your
itself.
lordship.
Yes.
Of the day, no can
Yes,
already.
Mr.
Yes.
Yes, Mr.
Yes.
My lord, I am appearing for the applicant of Can 2. I am the nominated member. My name is Sagnik Chaudhary, nominated in the by order dated 28 July 2025. The notification which the writ petitioner has challenged.
Yes.
My lord, in my application, I categorically stated that, my lord, if you, I am requesting you to kindly come to paragraph 18 of the Can 2. That is at page number 11 of Can 2 application.
What is your grievance now? What you want?
My
I am
lord,
disposing of the writ petition on merit itself. So nothing remains.
my lord, my submission is that even if my lord held something different, only 4 to 5 days are left. My proposal is, as per their claim, my proposal is let my name be kept in abeyance for 3 to 4 days, but the committee of nominated members should be constituted because this paragraph 18 reflects the most important functioning of the pharmacy council. That is not going on. The duplicate certificate renewal, duplicate registration, new registration of pharmacist, the investigating officer to be appointed who daily conduct the rates and quality of medicine supplied in the medicine shops. So all these functions are totally stalled for last 6 to 7 months.
Okay.
Lordship, I am the Can applicant, Can number 3, Lordship, which has filed on 6th February, Lordship.
Yes.
Lordship, 1 minute, Lordship. At the same time, Lordship,
So
I am the
you?
writ petitioner of the...
Who are you?
I am saying, Lordship, I am the writ petitioner of the item number 17. I have several allegations against nominated member which is pending. I am Lordship praying that this person should not repost in his position, Lordship. Can 3, Lordship, I want to respondent party in this matter, and in my writ petition, Lordship, item number 17, Lordship, it is pending in this bench, Lordship.
What is your writ
Lordship,
petition?
I will be effective. Sorry, Lordship.
Yes, 17. What is
Sorry,
your
Lordship,
writ
pardon
petition?
me.
What is your writ
Lordship.
petition? What you have prayed for?
I prayed for judicial inquiry against the elected and nominated member. There is an irregularity. That's why I am enjoying the interim order of the coordinated bench. One second. Secondly, here, how I connected item number 6.
Separate
1
issue.
second.
Here the issue is the right
No,
of a
Lordship,
nominated
kindly
member.
give an opportunity. 2 minutes, Lordship. kindly give me an
Nothing to do with
opportunity,
the
Lordship,
other
because I am
Item 17 can
confirmed
be
them,
heard
Lordship.
independently.
Lordship, once again,
totally different.
I am opposed the prayer number of C of this item number
Yes, what, Mr.
16,
Lahiri, what
Lordship.
is your contention, sir?
Would your lordship take up after recess or continue?
Yeah, continue.
Now, my lord, first point, may I just take it from the last? First is they are trying to substantiate that the council is not functioning. The persons who are not yet there in the council are trying to substantiate that. Now, kindly takes up the affidavit in opposition of the council itself. I am dealing it from the last first category. This is a thin affidavit, my lord, affirmed with the back sheet of Mr. Boiddo. Parashar Boiddo back sheet.
Petition. 1778. This 1778.
Affirmed on 20th January 2026.
Affidavit in opposition, ये अलग है.
Affidavit in opposition of the council. I have also relied upon that affidavit when I placed the writ petition.
Affidavit in opposition?
Yes, this affidavit. প্রশান্ত বৈদ্য দেখুন ব্যাকশিটে আবার ওটা
Yes.
Now, my lord, first is kindly comes to page 4 of the affidavit.
Yes.
Where, my lord, paragraph 4, subparagraph J is there. It has been written that although at present the council is functioning with the existing members of the council, but since general election has already been complete, so therefore it is need of the hour to give it. So therefore, functioning. Now, what is the quorum of functioning? That will be appearing, my lord, from the rules of management, where it is specified that, my lord, meetings of the council, the quorum is 10. Quorum is 10 members. Kindly sees rule 8.
Rule 8
of this is, my lord, management of property of state council, the maintenance audit such and such. So this is, my lord, the meeting of state council where it is written and the quorum is 10. This is, my lord, I have marked out of 14. Now, my lord, kindly sees another document, that is my reply to the affidavit affirmed by the council. রিপ্লাইটা দেবেন 28 জানুয়ারি 2026। দেখুন উপরে ছাপ লাগানো আছে।
Affidavit in reply.
Yes.
Yes.
Now this is the notice which was given. Page 8.
Yes. Page 8 is the affidavit portion.
No, well, this notice. It's in the back sheet of Mr. Samrat Depal. Affidavit in reply to the writ petition.
Applicant in
28 দেখুন।
Affidavit in reply filed on behalf of the writ petition to the affidavit. That's one number 3.
Yes.
Yes.
I had drawn your lordship's kind attention to this affidavit earlier also to substantiate that
for election of the person vice president, council in view of the fact government was. Yes.
However, please note that the office of the West Bengal Primary Council will function as usual on and from such and such. So therefore, these persons who are not there in the council, the allegations that they are making that the council is not function is not true. Why it is not true, I'll substantiate. Now kindly takes up the writ petition. The functioning is to be done. The document with the functions which they have, my lord, mentioned are guided by section 39, where it says that the registrar will do all the, my lord, issuance of certificates of registration and all this. That is at page 37. Section 39.
Yes.
Issue of duplicate certificates of registration and all these things, where it is shown to the satisfaction of the registrar that a certificate of registration has been lost, destroyed, registrar may on payment of such and such issue duplicate certificate. Thereafter, restoration of the register, everything is being done by the registrar, and my lord, admittedly it is functioning. So therefore, the impression first which has been given that it is not function is not true. Now, may I come to the second point, as it has been argued. Now, the submissions of learned senior advocate Mr. Kaur is based on, my lord, facts which are not appropriate. It has been submitted before your lordship that there was a void from 2018 to 2021, and therefore the appointment of the nominated members and the elected members are coterminous. So if the term of a nominated member is terminated, the elected member's term also terminates. If the term of an elected member is terminated, the term of the nominated member is also terminated. On the basis that from 2018 to 2021, there was a void. Now kindly takes up the, again, affidavit of the council. Page 5, paragraph 8. This previously I have drawn your lordship's kind attention.
Yes. Yes. Page 5.
Paragraph 8.
Yes.
First is denied dispute. The last sentence in paragraph 8. It is categorically stated that the election of the council was due from 2013 due to its various reasons controlled before the council. So therefore, from 2013, there was no election. From 2013, no election. The previous election was in 2007.
Yes.
Which expired in 2013. Thereafter, my lord, in 2018, I was nominated again. So 12 nomination. Thereafter, in 2000, from 2000 till 2021, I was nominated. 21 I was nominated. Yes. So therefore, it is not coterminous. It is not, my lord, anyway connected with the election. Election is different. Statute itself says. Now kindly comes to 19, section 19, section 25. So the submissions made and the contention tried to be substantiated before your lordship is not on the basis of facts, which is contrary to their own stand. So from 2013, there was no election. There was council. As I was elected, I was nominated again. Now kindly comes to section 19 again.
Yes.
6 members, the constitution of the council, except where a joint such and such council, it is not a joint council, the state shall constitute a state council, constitute of following members. 6 members elected from themselves. So this is 6 independent, thereafter B. 5 members of whom at least 4 at least 3 shall be persons possessing the prescribed degree of such and such pharmacy or pharmacy chemistry or 5 registered pharmacists nominated by the state government. I am one of the registered pharmacists. I have been nominated. Now, my lord, these 5, thereafter 1 member elected from amongst themselves, member of the each elected from amongst themselves by the members of each medical council or council for medical such and such. So 5 plus 1, 6. Thereafter, the chief administrative medical officer of the state ex officio, or if he is unable to attend the meeting, a person authorized. So 1, so 5, 6, 7, and 6 is the officer in charge of drugs control. So therefore, my lord, the entire thing is independent of each other. Now, my lord, kindly sees the section 25.
Yes.
Which is, my lord, which has been shown to your lordship. Oh, previously my paragraph 4 has been shown. Yes. So therefore, I should place paragraph 4 plus first, page 4 of the writ petition. Paragraph 4, my lord, the last sentence has been placed. The first sentence has not been placed. So the entire paragraph has to be read. In the state of West Bengal, the Pharmacy Council constitutes of the aforesaid members whose tenure constitutes of 5 years. It is been specified that a nominated or elected member shall hold the office for a term of 5 years from the date of his nomination or election or until his successor has been duly nominated or elected, comma, whichever is longer. So that was my point. Whichever is longer is the most important, my lord, phrase. Now, kindly comes to page 29, which is, so therefore, this paragraph, my lord, as it has been erroneously sought to be agitated before your lordship, that I have admitted that is no admission. I have contended that now the contention I am trying to substantiate kindly comes to page 29. Section 25 has been placed time and again. May I again place, my lord, in my way, subject to the provisions of this section, a nominated or elected. So nominated for nominated members, elected for elected members, other than nominated president. Nominated president is nominated between the members. So this is not the nomination here. Shall hold office for a 5 years, for a term of 5 years from the date of his nomination or election. So nomination for the nomination members, nominated members, election for the elected members. That is 19A. Or until his successor has been duly nominated or elected, whichever is longer. So this is the main phrase, my lord. So therefore, the contention which has been sought to be, my lord, agitated before your lordship by the learned additional government the learned additional advocate, is that it is with a retrospective effect that this term has been given in 2021. So therefore, his calculation is from 12 to 18, thereafter 18 to 23. So from 23 onwards, his contention is that vacuum. Now, my lord, kindly comes to the order itself, page 43, by which 40 can. Yes. Now, my lord, kindly says page 41 again. Page 41 is 5th October 2012. Now, kindly sees the names of persons who have been nominated with me. I am item number 2 there. Now, 1 is Robindranath Devnath, same. 2 is me. 3 is Sukumar Das. 4 is Topon Kumar Chatterjee. And 5 is Kamalesh Purokayat.
Yes.
Now, my lord, if the contention of the state government is that this is with retrospective effect, now kindly comes to page 43. which is the 2021 nomination, Lordship would see, first is it doesn't say with retrospective effect, so therefore an administrative order which doesn't say that it is with retrospective effect cannot be given any retrospective effect. I can, my lord, substantiate this point of law with judgments. Page 43, it doesn't say retrospective effect, so therefore it is not retrospective effect. It has to be construed with a prospective effect. First, this is the basic principle of administrative law. If your lordship is of the view that I should substantiate this with judgments, I can. Next, that works. So it doesn't read that it is with retrospective effect. Now kindly, 1 and 2 are the same members of the previous council. 3, 4 and 5 are different. So if the contention of the state government is that this is continuation.
No, not there. It is not the continuation.
With a retrospective effect.
No, not retrospective effect. They are telling that the tenure was over on
In
18.
2020.
18 tenure was over, but 2021 there was no election or nomination. That's why they have taken on 22nd January with effect from 18 June 20. This is the content.
It doesn't say so.
No, this is the content.
There's the contention. Now, what even if it is from a previous date, so therefore their contention is not that it is continuing.
No.
I understand. So therefore my contention would be, my answer to that would be that it doesn't say so.
Your continuation is after this 2023.
2023,
because if 18 June 2018 is taken into consideration of 5 years, the 5 years has been completed on 2023, but it is continuing. Now they have conducted the election in 2020.
Election is not relating to me.
No, nomination and whatever.
Nomination.
Both has come on July 2020.
That is they have. That is why I am challenging one administrative exercise, that there should not have been the impugn notification, ought not to have been issued. Now, my lord, here, so that they are now trying to read into things which are not there in the administrative instruction, which is not there in the order. And my lord, even if it is constituted that, my lord, 2023 was, my lord, the expiry, which has to be from 2018 onwards, my lord, then in that case, the word whichever is longer is not being read in section 25, which is the interpretation of the, my lord, Tripura High Court judgment, which I have cited. That, my lord, yes. Now, my lord, this is, my lord, another, my lord, it is apparent from the order itself. It says on expiry of the terms of the West Bengal State Pharmacy Council on 18/6/2018, governor is pleased to such and such. So therefore, it is apparent that from 2018 it expired, 2021. So therefore, the period in between is whichever is longer clause will be covering. And as it has been done by the and as it has been interpreted by the Tripura High Court judgment, but that I have cited before your lordship. And my lord, with regard to the contention, yes. Now, my lord, say for instance.
So what benefit you will get if whichever is longer is taken into consideration?
Whichever is longer is that, if whichever is longer is taken into consideration, then my tenure would continue till 2021.
Correct. No, that's
not.
They
are saying my tenure would be. They are trying to substantiate that in 2018 it has expired.
Correct. So they are telling that yes, it was expired. 2021 again pass ex facto approval, and you continuing with that. Now it has.
My contention is
your main contention raised by the authority that after 2023 you are again continuing. They are not telling that you are illegally.
Yes.
But 2027 once that July 2025 when they have nominated, you have no authority now. You cannot challenge that.
Their contention is that from 2018 it has to be counted. So if it is from 2018 it has to be counted, then the words whichever is longer is not being read of the statute. Why this word which has been written there in 2000 section 25 is whichever is longer.
Correct.
So even if it has expired, say for instance these words were not there, whichever is longer. Now let us proceed on the basis that these are not there. Whichever is longer term is not there in section 25. Then their submission would have been appropriate that the term has expired in 2018. 12 to 18 expired. But since the term is whichever is longer, it has to be constituted that it was continuing.
So as per your submission, as per section 25, whichever longer is taken into consideration, so unless and until the nomination is not been done, so you continue that.
Yes.
So the nomination has been done in 2021, so your nomination is taken 2021 only.
The impugned order which has been issued prior to the expiry of the term,
so that cannot be,
would have to be
given effect after that.
Would have to be quashed and set aside.
Correct.
This order, if it is quashed and set aside, and until another nomination is made, my lord, again this will continue because there is a dichotomy in their own submission.
Okay.
Say for instance, so their contention is that the term expired in 2018.
Yes.
Now, my lords, they have nominated again me in 2021. So their contention is 2018 to 2023 was the term. Then what was happening from 2023 onwards? They will say that whichever is longer is the term. Otherwise, how I am continuing in the office?
Yes.
So the state government is taking self-contradictory stand. Once they are saying that, look, first is that it doesn't say so. Nothing can be read into this administrative my lord, orders which is not written. Second is, even if they are trying to give a retrospective effect, it has to be specifically written because it is an administrative exercise and it will be prospective in nature. Third is, if they say that it is 2018 and the term has expired, then in that case in 2023 itself, when the term according to them has expired, then 2003 to 2025 they are taking shelter of the words whichever is longer. So in one submission where it is advantageous to them to substantiate the impugned order, they are not taking into account the term whichever is longer, and in subsequent stages from 2023 onwards, when they are trying to substantiate, they are relying upon basically on the term whichever is longer. Okay. So to substantiate this.
That's all.
Yes. Another point, my lord, my learned junior wants me to point it out to your lordship. The impugned notification also doesn't say. Let's say, for instance, according to them, if that was the stand, that 2023 it has expired, from 2018 to 2020, the impugned notification also doesn't say that. It says on expiry of the terms of such and such is pleased to reconstitute.
Correct.
So therefore, if their contention is that in 2018, then it should have said that upon expiry of the council in 2023, this is being reconstituted. This also doesn't say. So therefore, everything is as it has to be, as it is there and is apparent from the record, is prospective in nature. Second is, there is no connection with the elected members. Third is, my lord, the contention of the my lord, council with regard to the void being from 2018 is erroneous and not it's contrary to their own affidavit. And my lord,
that's all.
Yes. Now, my lord, another
Lordship.
Page 20, 2021. Another yes. This I missed out. Kindly comes to page 43. If, my lord, so new members have been elected and has been nominated in 2021. Previous 3 members who were there in 2018 have not been renominated. Now, my lord, if their contention is taken into account, then these new nominated members will be having in 2021, page 23, 43. So there were new members who were nominated along with me. 1 and 2 are the old members who are continuing.
Correct, you are continuing.
Now the new members who have been nominated, then their term will be only for 3 years. Because they are nominated for the first time in 2021. They are please. I'm trying to make out a point. Please do not try to interject. So these three persons or persons who have been newly nominated in 2021, if their contention is appropriate, then they will be only having a term of 3 years, not 5 years. Because 23. So
no, why 23?
Because according to them, from 2018 it has to be calculated.
18.
So 2018 onwards, these 3 persons were not there in the board. These are new persons.
Correct. These are the new persons.
So if their contention is that from 2023 it has to be counted, then how would the tenure of these newly nominated members would be counted? Okay. So according to them, these newly nominated members who were not there in 2018, their term will also start from 2018 when they were not born in the council. Am I being able to substantiate this point, Malad? And if their contention is right, then these newly nominated members in 2021 will have only office for 3 years, which is contrary to the statute.
Yes.
These are my submissions.
Well, only answer to this, Lordship, one line answer. Retrospective.
Reply.
Just a minute. Not reply to reply, but it's a new point. That is why.
No.
Retrospective
Tripura judgment I have given.
Lordship. Please, retrospective effect given only in case of the writ petitioner, Lordship, not the council.
It doesn't.
Lordship, kindly consider.
It doesn't.
Not in terms of the council. Retrospective effect given in terms of his nomination. And the 5 years, he said, my lord, he has read 5 years and then whichever is longer. In between this, there is another phrase. Until the phrase nomination is made, whichever is longer. Here the phrase nomination made in 21st. So whichever is longer, that means up to 20. Kindly consider, or up to 23.
My lord, may I give the judgment with regard to administrative questions? I'll give it tomorrow.
5 years or until fresh nomination, whichever is earlier. After expiry of 5 years, fresh nomination, so end, chapter end.
Okay. I'll give the judgment tomorrow, my lord. I'll just, my lord, mark out, my lord, and give the judgment.
Lordship, kindly give me 2 minutes, Lordship. If the Lordship want to dismiss the case,
my lord, my lord, urge the point taken to be taken by the other 4 nominated members, your lordship.
My lord, my CAN application where I have proposed that if my lordship wants to continue the interim order, then my proposal is that my nomination.
So, my lord, from 2, my lord, I think, my lord, they will not be there.
Lordship.
News are reached to my lord.
Interim order is expiring today.
Which one?
No. Item number 4, which is fixed at 2.
I will come.
Well, if they are not there, my lord, then
I will come there.
My lord, if lordship wants to, my lord, if my lordship wants to,
if kindly lordship allow me to satisfy the court, lordship, regarding my points, lordship.
178 of 2025, along with the connected applications. Hearing concluded. CAB.
Grateful.
As regard, वो दूसरा वाला तो.
In this,
before passing the order, lordship, kindly allow me, lordship, to think, lordship.
The matter I have argued.
Interim order is extended till the final order is passed.
যেটা আর্গিউ করলাম এটা কত নম্বর?
Lordship, kindly allow me, lordship, for 2 minutes, lordship. Lordship, I am not getting the opportunity, lordship, to say, lordship.
The disposal.
7563.
Lordship, I am not getting the opportunity, Lordship, to submit my fact, Lordship.
Connected application be listed for hearing on be listed under the same heading on 25th of February.
Lordship,
অনেক কথা বলেছে বাবা, ছাড়ো না।
Lordship, I am not, Lordship, kindly.
দেখো কালকে কি
What about the other other writ petition?
Well, that is absolutely undefined.
Lordship, I am here, Lordship,
Direction
for
to
that, Lordship.
both the
Lordship, may I audible, Lordship? I am here for
Well,
that,
may-
Lordship.
that
Item
may be
number
detached, my lord.
That may be detached, my lord.
No, Lordship. I am kindly
Well,
allow me.
This is a separate matter. Let me appear on a
This is
separate
my
date.
petition. Kindly allow me, Lordship.
And that is also a hearing matter.
Lordship, kindly allow me, Lordship. Item number 17, Lordship.
কি বলে যাচ্ছে কখন থেকে?
By which order? 3rd of March. There is no order.
Someone may, my lord, a new writ petition is being filed before your lordship by my lord and party.
No, my lord.
I am asking the 17 number.
Lordship, I am the petitioner,
Why you are
Lordship.
making confusion?
No, my lord, I'm sorry.
I am the petitioner, Lordship. Item number
That's the
17,
problem
Lordship.
with you.
My lord, these matters were kept on.
তুমি
3rd
চুপ
of
করো
March.
না একটুখানি প্লিজ, তোমাকে তো বলতে বলে।
I am asking these two matters of tag. So you are telling that the another matter is different. He is telling that the same.
No.
So I am asking where is the, and you are telling that it has been detached and it is fixed on 6 months. Where is that order?
My lord, upon mentioning, your lordship has kept those matters on 3rd of March. That
Which
is-
matter? This matter?
No. Please.
Why you are asking? Why he is submitting?
Lordship, I am the petitioner of item number 17.
Yes, what is the contention?
Lordship,
So
kindly,
this, your
kindly.
petition will be taken subsequently.
Okay, much obliged.
Whether there is an order for hearing of the analogous hearing?
Yes, Lordship.
By which order?
Lordship, kindly order dated 27 August 2025, Lordship. 27 August
There is no order.
2025. Lordship, last paragraph number 4, Lordship, this matter will be heard along with WPA number 17878 of 2025, Lordship.
Yes, though
Order dated-
how it can be detached? There is an order. So this
And
matter-
also,
this
Lordship,
matter needs to be heard. Okay,
and also, Lordship, dated
17 is concluded. Full stop. It is fine from the record that order that by an order dated 27th of August 2025, this court has passed an order for hearing the WP number 7563 of 2025 along with 17878 of 2020. Let the WPA number 7563 of 2025 be listed tomorrow.
Lordship, and the order number
Yes,
3rd
I
April, Lordship,
That
that is
matter
also, I am entering interim order also,
1
Lordship.
PM matter. 1 PM matter.
Ah.
I make a mistake by releasing them. Can I keep it to tomorrow? Today there is.
Which has not taken, it will be taken tomorrow.
And 2 PM matters, my lord, I'll come back.
Let me see the
Maybe
what is-
difficult.
Much obliged.